May pardon to mention that. The year-old case, CRLA 281 of 2009, previously it was listed before your Lordship Court, that is Union of India, CBI case. So, today in the list there is some CBI matter, vigilance at CBI matters.
You give the memo with
Yes.
CRLT. Huh?
Pardon to mention,
If it is there, then they have.
Previously it was listed before your Lordship Court. Previously it was listed.
pardon to mention, my lord.
No, I am taking the matter serially, you know.
Yes, it is
Year wise.
we are ready
That may
for.
be the reason it is.
We also prepared a short note briefs in the so we submitted the note and plus
Okay,
arguments.
no problem. Yes.
Pardon to mention, my lord. CRL number 751 2024. It is I guess
24.
24, my lord.
Why are you mentioning this in this court? 24 somewhere else. Maybe.
Pusko.
It's not in this roster. Okay.
Okay.
Find out the roster and mention it. Yes.
My lord, item 9 of today's list, Lordship. That
Mhm.
Mr. Mahadi is on accommodation till next week. So, Lordship,
Let it be there in the list. Don't worry.
I know.
Nice.
My lord, he's on accommodation till next week.
Yes, yes, no
Fine.
problem. 9. No problem. Yes.
Much up.
Yes. Any mentioning anywhere? Yes.
Item 1.
Item 1 is alive, Your Lordship.
Right. Okay.
Yes.
Take the. Yes. Ready for hearing? 91. Retaining the list. Huh? Retaining the list. Not going. You are appearing?
No. May I
Who
be
is-
pardoned to pray for adjournment of item 51. My lord, we are unaware.
Matters will not be adjourned. It will be there in the list itself. But I'll accommodate you. So it should continue. The
My lord, I
present will be
pray
there with you. That matter is there.
My lord,
Get
I
ready.
pray for. My lord, I pray that you may call for the status report of the appellant. We
And
don't.
see, status report is required or not, I don't know. Let it be there on the list. Huh? This item 2.
Item 2.
You Lordship, item 2, I need some time. As per the oral instruction, the person is alive, Your Lordship.
Get this instruction. Instruction awaited next week. Let it be there in the list. Huh? 91 matter. You get the list. Okay. Adjourn to list. Yes.
Item 3.
Yes, sir.
Item 3, my pleasure, Lords.
Contempt.
Yes, madam.
Which order?
So order Annexure 2 to the content petition.
Annexure 4.
2, madam.
2.
The order dated 12/9/2023. Page
No,
20.
what was the direction?
Direction to consider the case of the petitioner. Page 26, madam. Running page 26.
36.
Yes.
You have the following, I am not the-
Thereafter, my lords, they prefer the
petitioner, details, about the direction to the department of the case of the petition. Give appointments, Yes.
they prefer the
Yes,
intercourt
Mr.
of
Yes, Your Lordship. Instruction let come next week.
Okay.
2 weeks after. I will
If you
take-
notice,
Thank you.
Mr. Das accept notice. Release the matter after a week, after
weeks,
2 weeks, after 2 weeks. So that's it, huh?
Thank
Yes. Okay.
Item 4.
Yes.
My lord.
Yes, Mr. Padra.
My lord, only because
This is for what? This is for final disposal. What? 482, why it has come?
my lord,
The principle of the record, it appears that.
earlier petition was before this court, therefore, my lord Justice Mahapatra was of the view that this should be placed before, my lord.
By the coordinate bench. This court periodic or so. And which was that order which I passed earlier?
That, that is at. This is the order, my lord, that is 84. Based on that Kejriwal judgment, my lord.
This is judgment.
That is, I have annexed, my lord, that is at page 51.
51. 51, yes. Earlier you approached this court
Yes, ma'am.
and I have disposed it up, huh?
Yes, ma'am.
Saying what?
Saying on all these issues, once the delinquent officer has been exonerated by the departmental inquiry, the criminal proceedings should continue.
Continue.
That is, I am not on that, my lord.
Hmm.
My lord, I am on a basic point because the notification by the vigilance to investigate the cases under MMDR Act is in 2010. This FIR was registered in 2009. Therefore, when the FIR was registered, they had no authority. My lord, may just turn to page annexure 8, page 121.
121. Yes.
My lord, may I read, my lord, with your permission?
Yes.
In exercise of power conferred by clause A of section 2 of CRPC and in supersession of notification of Government of Odisha in Home Department number so and so dated 13th July 2001, the state government do hereby declare that the offices mentioned in column 1, schedule 1 shall be police station which shall include within their respective limits the area specified against each in column 2 of this said offence for the purpose of the offence contained in schedule 2 below with effect from the date of publication of this notification in the Odisha Gazette. My lord, may then turn to page, schedule 2 in the same page. What are the offences? This they should investigate.
Yes.
From offences, my lord, from A to F, there is no offence under MMDR Act. My lord, this has been amended in 2010. They enlarged the jurisdiction, but that is at page 123, my lord.
123.
123, my lord.
Yes.
And my lord, the
The notification which you have read is amended now.
yes, my lord. This
Yes.
this is 7th August 2004, and by this notification, the jurisdiction has been enlarged
Hmm.
in 2010. And at item 15, my lord,
Yes.
the Mines and Minerals Development and Regulation Act
MMDR
1950.
has come.
My lord,
This is in 2010.
10, my lord. In the next page, my lord, the date is there in 2000. Now, my lord, turn to our FIR. This is in 2000.
FIR is on.
FIR is page 9.
FIR.
FIR of the present case, my lord.
Page
Page
9.
85.
What is the date?
Page 85, my lord, that is
2009.
2009.
That
This is 22nd
22
September
9, 2009.
2009.
Okay.
This one.
Offense is section
Offense is with all of my lord, this
21.
IPC and
Under
PC Act
section-
and also Mines and Minerals Development and Regulation Act.
21 of MMM.
Yes, ma'am.
MMDR
Act 1957.
here and 120B.
IPC and PC Act. 13.2 read with 13.1.
and 13-130.
Yes, my lord. My lord, and this also, my lord, may see. Apart from that,
So then what do you say? What about the PC Act and 120B?
my lord, PC Act and that I'm coming to that, my lord.
Hmm.
My lord, just see the district Baleshwar Vigilance Police Stations.
Yes.
And now, my lord, in the contents,
What you are trying to say is the Vigilance Department could not have investigated an offense under MMDR Act
yes, my lord.
before 2010 when
right.
it was amended. That's
Yes,
what your whole
yes,
case.
yes, my lord.
That's what your whole.
Apart from that, my lord.
Yes.
Apart from that, what they have done.
Because earlier notification had not included MMDR.
Yes, my lord. Yes, my lord.
In
In
only
2004,
2010 it was
yes, my lord.
added.
Yes, my lord.
So therefore, since it is an FIR of 2009, the Vigilance Department had no job, no authority.
They could not have
investigate
registered this
into
FIR.
an offense, particularly under an MMDR.
MMDR.
This is the whole.
That's my. That's my.
Yes. 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 Which para? But this judgment is on a different. Okay. 14, 1-4, yes. The petitioner namely. It is also a list.
It also earlier petitioner had applied this court in 7 against the province order seeking passing of the entire proceeding. I am taking a pause here. They are this plea was there. 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 They are this this particular place now they are raising, that was there, number one.
Hmm.
Then however, the same was dismissed. Again, petitioner by filing criminal division number 5.2 of 7, challenge the order of rejection of discharge petition, ODS address purpose. So the same was also not entered in the discharge as that time charge had already been framed. There that plea was. Then again.
In the charge stage.
In the discharge petition.
Discharge petition also it was.
This particular.
Yes.
And again, the petitioner has approved this court by filing criminal division 365 of 18, which was disposed of Hon'Ble giving liberty to the petitioner to raise all such contentions at the time of trial before the court. Then this plea or particular plea was also there. This was important not entertained, and they have not approved.
Yes, Mr. Patra, if
No, my lord, my lord, my lord,
if
my lord,
pleas
this
were-
plea-
if pleas were taken and the
No,
court has
plea-
attended to.
No, yes, my lord. What happened? Pleas were taken and I was directed to raise all these pleas before the London magistrate, London special judge. Then, my lord, the developments happened, then I was exonerated, then I was before my lord. My lord, while disposing of this issue, has not adjudicated that issue because I have also annexed the petition. Apart from that, the departmental authorities, I have also raised this issue. It was not adjudicated. My lord adjudicated that because
In the cognizance order when it was challenged, if you have taken that ground, it was dealt with or not? Where are those orders?
That order I can place, my lord, but I was directed to.
See, what I can do is at best, what can I do is I can only issue notice without any entry.
My lord.
Yes.
Then the last revision petition, this particular plea was there. It was dismissed with the liberty to raise all pleas at the time of trial.
Hmm.
It was not accepted before the appeal. If in 3 petitions.
But subsequent to that order, whether they moved application?
No. And your 3 petitions prior to your lordship's judgment was dismissed on particular plea was there.
I know.
And it was not accepted for this honorable appeal.
But if the liberty is granted to you by this court while disposing of a revision petition 365 of 2018 to raise all the point, why have you not raised?
No, my lord, thereafter, the pleas were raised before this. Then, my lord, what happened?
When have you raised? After this 15 to 2019?
Yes, because along with
When have you moved application before magistrate saying that this liberty is granted to me to raise this point? I am raising.
that
And-
that application I have not annexed, my lord. I can annex those applications. But what happened, my lord, in the meantime, I was that the departmental inquiry report has come. I was exonerated. Therefore, I filed a comprehensive petition mentioning everything before this court. And unfortunately,
Cognizance taken in which offense?
MMD Act.
Only.
No,
Only.
IPC.
Along with the.
IPC.
All these 3 petitions, earlier petition, the order was not challenged before that. Again, this taking particular plea, that departmental proceeding and criminal proceeding. On the ground of exoneration department.
Yes, sir.
criminal proceeding. Your lordship attest to that and dispose of that question that will not enter. It was also not accepted before the order of this court. That it has attended on finally. Another aspect is the plea of a departmental proceeding was also earlier there.
No, I'm not touching that aspect at all.
The particular plea now he is raising in this petition, filing this petition was earlier in 3 petitions.
Where are those? Can I get those?
That is there. That has mentioned your lordship judgment.
No, that's right. But I want to see
But the issue
whether-
has not been
that
adjudicated.
whether in the cognizance petition this plea was taken, and again in revision 2017 it was disposed of. 2019 it was disposed of.
That you are there. And another aspect is most important aspect. The cognizance. There was no bar. So section 22 MMDR specifies a bar to take cognizance. No court shall take cognizance. Your lordship kindly take on to page 125 of the petition.
Petition 125.
Annexure 125 page.
Yes.
Section 22 cognizance of offense.
Hmm.
No court shall take cognizance of any offense. The lordship take petition.
125 section.
Section 22, my lord.
Cognizance of
Yes,
offense.
yes. No court shall take cognizance of any offense punishable under this act.
Where there are no, except of competent written, like in writing made by person authorized on them. So by the time cognizance was taken, we have the authority. So cognizance was what? Not investigation, not FIR. Cognizance and taking filing FIR or complaint is different. And that has been duly addressed by.
What was the notification says?
No.
Investigation or
हमको authority दिया था हम investigate कर पाए. Whether the authority, हमें we filed charging in 2014.
when the cognizance is taken?
Cognizance is asked in 2014.
Okay.
And another aspect, this particular issue was before this honorable court and went to apex court also. That has been confirmed. It is a matter of time. In other cases, on other mining cases, that has been announced. So this issue is no more less integral. It has already been decided by this honorable court and not apex court. So filing petition after when witness is going on. prosecution
What is the stage? What is the stage now?
Witness is going on, and I am coming to another point of law. The point of law is this honorable apex court referring to the earlier judgments of honorable apex court to short track and filing of sanction ASB. That is referring to Ratilal Bhadralal Smithani case, 1979 Supreme Court, and Sri Atyachar Virodhi Commission case. That referring to that case, on once charge has been framed, the accused is put to trial, and thereafter the accused may either.
It's not open. It should not open for 480 court to get into all. There's a subtle principle.
But my lord,
It's very clear.
if
What are you seeking by the corresponding?
my lord, one thing, if I can
Much
demonstrate.
water has already flown under.
No,
the bridge.
that's right, my lord. But if it is from the very beginning, it is illegal. What my friend is now saying, ki we registered this case in 2009 and we.
You have to meet 2 points.
My lord.
First of all, section 22 says no court shall take cognizance.
Cognizance, yes.
Cognizance is what investigation is not.
Yes, ma'am.
That's what he says.
Yes, ma'am.
In any case, in 2009 the position was different, and 2010 the notification was amended, and they have been
No,
authorized.
that is also what 2010 notification says.
When the charge sheet was filed.
2014, after 14, 2000. Let us this, my lord. The charge sheet was filed. Exactly the date is.
You give a list of dates. Let me see. You give a list of dates.
And my.
No. See, what will happen is, if I'll not stop here, it will go on and on. I want to write this kind of.
My lord, one more thing, my lord, just see 121.
You have to stop somewhere. You have to put in.
My lord, my lord, this is how the vigilance is operating.
Hmm.
My lord, just see, this is 121 at serial number 3. Office of the SP Vigilance Balasore is having jurisdiction over Revenue District of Balasore, Bhadrak, Mayurbhanj and Keonjhar. And this is admittedly a case complaint was filed by an inspector of Cuttack, investigated by him. He was having no jurisdiction.
Those things are
That
not.
I understand because of
only
156(2), my lord may say these are
only the thin question of law
yes.
which we have raised that could be addressed, but the fact remains,
My lord.
that you have raised those points time and again,
No, but
where
my
the
lord,
court has attended to that.
No, my lord.
That's the whole
my lord,
difficulty.
No, my lord, what happened? My lord directed us to raise the plea before the special judge. Then what happened?
Where have you raised those pleas?
My
On
lord,
getting liberty.
My lord,
Show me you have raised the point, and the magistrate has done passed some order, and show me that order. If that order is wrong, I'll interfere.
No.
This petition was also challenged before this honorable court.
So those things are not there.
My lord, what?
Get an exhaustive list of dates.
I will file an exhaustive list of dates.
Giving all whatever you have to meet.
Yes, yes, I will.
I'll just note it down so that easier you give the list of data. You have shown me page, sir. Which para you have shown me?
Para 14 of the
14 years.
yes, my lord's earlier judgment.
Yes, right. In this petition, petitioner is assailing, seeking quashing of the FIR numbers also, and the entire proceeding germinating out of the said FIR. The sole question raised by the petitioner in the present petition is that the government, Home Department, government of Orissa, by notification dated, first notification is dated
7th August 2004.
7th August 2004, mm, um, empowered the Vigilance Department to investigate into certain offences.
Mention
As various type of offences, wherein the offence under MMDR Act of MMDR Act 1957
yes, ma'am.
was not included. When the matter stood thus on 22/9/2009, an FIR has been registered against the petitioner for alleged commission of offence under section 21 of MMDR Act 1957, along with the offence under section 13(1), 13(1) D, 13(1) and 13(1) D, FIR read with the section 120P IPC. By taking me to the Annexure 8 series, Mr. Patro, counsel for the petitioner, submitted that the notification dated 7/8/2004 was amended amended by separate notification dated 14/1/2010, whereby the offence under the MMDR Act, Mines and Mineral Development Regulation Act 1957, has been included. Therefore, Mr. Patra submits that when the investigation was carried out and the charge sheet was filed by the Vigilance Department, the department had no authority to investigate the offence under MMDR Act. Per contra, Mr. Maharana, taking me to the judgment of this court passed in CRLMC 2783 of 2021, Rikiram Chandrasekhar versus State of Orissa and batch matter, submits that exactly the same plea has been taken by the petitioner time and again. He submits that earlier the cognizance order was challenged, where this point was precisely taken. Subsequently, thereafter, two criminal revisions were also filed by the petitioner, taking exactly the same plea. The trial, this court thrice over has attended to the point raised by the petitioner in the present petition and non-suited them. He has relied upon para 14 of the Ricky Ram Chandrasekhar Supra, which reads as under para 14. The contention raised by the petitioner and the respondent take and Mr. Marana has also taken me to the which act is this? MMDR Act, section 22 of MMDR Act 1957, which reads as under 22 page here 120.
125. My lord, here
And
I
submits,
can.
referring to the above provision, submits that there is only bar contained under the provision for taking cognizance. However, the act doesn't debar investigation by the Vigilance Department. Pertaining to the offence under MMDR Act, particularly when other offences in under PC Act and IPC Act are also enjoined with the offence under MMDR Act. The contention of the petitioner as well as the respondents gives rise to various disputed facts, which is not succinctly coming in the petition. Therefore, both the councils are given an opportunity to file exhaustive list update along with by reproducing the relevant part of the orders passed by this court in different different proceedings referred to above.
And also, my lord, one aspect, if my lord, just, you have 22 says, cognizance, this is akin to official secret act, my lord, even though CBI filed a charge.
So that will you address that. I have
okay, my lord,
recorded.
okay, my lord.
You file the exhaustive
Well,
list update with
My-
along with
my-
that.
Okay.
You tell me when could be after 2 weeks or so. Yes,
Friday,
Friday.
Huh?
Thursday.
Friday, Thursday, and only Thursday and huh?
No, December, 9th December.
9 December.
No, Thursday is 11th, my lord.
11 also, 11 or 9?
11th.
11. 9.
My lord.
Then 16th. 16th.
Ah.
16th. Okay, 16th. But give me exhaustive and the orders which you are referring to, reproduce those part. Oh, it's all right. Yes. Yes.
Item 5, my lord, on behalf of Sunil Kumar Pandey. May I please your lordship, my lord, in the previous order, the PT case number was wrongly typed as 2588 instead of 8 of.
You want correction, huh?
Yes.
Only correction.
Yes, my lord, only correction. And previously the case was pending in the learned court of SDKM Jharsuguda, but currently it was shifted to the women's court Jharsuguda.
कर दो correction को जो भी correction चाहते हैं ठीक है okay
Item 6,
ये क्या है flag for dispensing with the addition of this scanned copy why it has come where has it come by why this is come only there now there none appears for the petitioner please the matter after lamba time yes
hearing.
hearing please oldest matter court location let us see 80
Item 18 the oldest.
7 ru आराम करो 7 ru आराम करो वो तो दिख रहा है yes
Item 7,
Wait, please, Your Lordship.
yes
Your Lordship, this is offence pertaining to 21 of the NDPS Act, Your Lordship. Wherein, Your Lordship.
you are supposed to give a written
Yes, Your Lordship.
you prepared
I was supposed, but the discussion was on section 55, Your Lordship. So Your Lordship had put me a question that whether it is mandatory to take the person to the gazetted officer or to the nearest magistrate, or they have to be brought here. Anyway, any which ways, Your Lordship, in this case, neither he has been taken nor has the gazetted officer been brought to him, Your Lordship. So, Your Lordship, I had looked into that proposition, Your Lordship. So there are actually disputing judgments to the word taken. The crux is, Your Lordship, if any which ways the investigating authorities are ensuring that while the search was going on, the magistrate or the gazetted officer were present, then it would be taken that section 50 has been complied with.
Right.
Your Lordship, that is. But in this case, Your Lordship, the things that are against me, I should apprise my Lordships about that, Your Lordship. So here we are saying that section 50 and 55 have not been complied at all. In the present case, Your Lordship, only the informant and the investigating officer, they are only supporting the case of the prosecution. All the rest of the witnesses have turned hostile, Your Lordship.
Investigating officer and
And the informant, Your Lordship. PW1 and PW8, Your Lordship.
why should you doubt them? Merely because they are government officer.
Your Lordship, I would not be, their case would have stood on their ground had their own, again, their own witnesses who were also witness to the search and seizure, they would have supported their case.
No, see, in all these cases, you will find invariably the private witnesses
No,
never support.
in this case, not only the private witness,
The-
the constables also. Yes, sir.
Constables also.
Yes, sir. Yes, my Lordship.
Yes. One is
PW1 is,
what is the recovery?
the recovery is 425 grams of ganja, Your Lordship.
425 grams.
Grams of ganja, Your Lordship. And ID liquor that has not been measured. I checked it from the accused statement, Your Lordship. That is not measured.
420 grams.
425 grams.
25 grams of ganja plus ID.
ID liquor, Your Lordship. One bottle of ID liquor is
One-
what?
one bottle.
Yes, one beer bottle
It's
is.
not measured.
No, not measured.
One. Yes. Not measured.
2 bottles of ID.
It is the sealed bottle. If it is a sealed bottle, then need not be measured.
That has not been.
bottles.
Hmm?
2 bottles and ganja. in
Two?
packet. 2 bottles.
2 bottles. Okay. You tell me who all are the witnesses, those who supported prosecution?
Your Lordship, PW1.
PW1.
PW1 is the informant himself.
Informant. PW1 info. PW1. Yes, madam. Let us see what he says.
I know
He's
the.
an ASI police, huh?
Yes, Your Lordship.
Yes.
I know the accused in dock on 7/10/1995. I was attached to Nayagarh PS as ASI of police. On 6/10/1995 night, I had been dacoity checking duty, and after returning on 7/10, it is 85, but should have been 95.
95, yes.
At 5 a.m., while I was checking duty of suspects and criminals, I found on seeing the police, this accused, identified, was moving in a suspicious manner. The accused was holding a foam bag in hand. On opening this bag, I found 2 bottles of ID liquor and ganja in a packet were kept in that bag. On being questioned, the accused gave his identity as Vijay Kumar Sahu of village Sanpur under Bolagad Place. Then I demanded any authority for transportation of liquor and ganja, but the accused could not produce the same. I prepared a written report at the spot, Nayagarh bus stand, stating the above facts and sent the report to IAC Nayagarh PS through Constable 344 Sudam Charan Naik, Your Lordship, turned hostile. This is my report marked as Exhibit 1 and my signature marked as Exhibit 1 by 1. I guarded the accused till the arrival of the IAC. On arrival of the IAC GP Das, he wanted to search the accused, and before doing that, he gave an offer to the accused.
GP Das examined?
No.
Das IIC not examined, huh?
No.
Okay. Proceed.
Yes, Your Lordship. That he gave an offer to the accused that he has a right to be searched either before a magistrate or before a gazetted officer. But the accused told him that he can give search before the police. Your Lordship may note this.
Yes.
And also before him, as he is a gazetted officer. He searched the accused and recovered two.
The IIC says that I am gazetted.
Yes, Your
Okay.
Lordship. He searched the accused and recovered 2 bottles of ID liquor and 1 ganja from the possession of the accused, Your Lordship.
Hmm.
he weighed the ganja to Lochan Sahu and it came to 425 gram. He seized the liquor and ganja in presence of it and prepared as a seizure list at the spot. He drew up samples of ganja weighing 50 grams and divided the same into two parts, each containing 25 grams. He sealed them separately. The remaining bulk of ganja was sealed separately. He put the brass impression of the seal and kept that seal in Jimma of Lochanzao. I can identify the bag and the ganja packet and bottles if produced in the court. A list was prepared on the spot and I had signed one. This is the seizure list and we brought the accused and the seized articles to the PS. Then in the cross he says, the accused was found standing in the bus stand where the buses are parking. That was a pouncia color bag which was held by the accused. On seeing me, the accused exhibited suspicious behavior. So I immediately caught hold of him and searched his bag. The ganja was visible from that packet.
I got hold of him and
Searched his bag.
search has already been done.
Yeah, he searches the
found
bag and then
in the chief also he says, I found that he is in possession of 450 some ganja and 2 bottles of ID liquor. For that
And he
intimated.
search has already been done by him.
Yes, Your Worship.
How can he do it?
He can do, Your Worship. Unless and until Your Worship, there are two different scenarios, Your Worship. One, when a police get a reliable information that some kind of illegal activity in relation to NDPS Act is going on, then he need to intimate to his superior officer before doing any act and make it to a SG entry. In this case, he was on a different duty altogether, on a dacoity duty, and this particular accused reflected some irrational behavior for
Okay,
which he
let
was
us
convicted.
read the facts first. Okay.
Yes, Your Lordship.
Yes. Read it.
I have not
Got
remembered.
hold of him and searched him.
Yes, Your Lordship.
Okay. The ganja was visible from that box.
I have not remembered if that paper pudia was tied by a sutuli or a chain. The liquor bottles and ganja packet were kept in one space of that bag. The IAC reached the spot at 6 a.m. The IAC GR Mahapatra, the SI GR Mahapatra also came to the spot following IAC. He recovered the bottle and ganja from that bag. I cannot say the time consumed in effecting the search and seizure. It is not a fact that nothing was seized from the possession of the accused, Your Lordship. Your Lordship, now he states two things. That I have searched the accused and then he says that he had a bag in which the ganja was found. So even if taking into consideration, section 50 is not applicable if things are recovered from the bag, Your Lordship, or from anything that is not my body, Your Lordship. But suppose here he is definitely saying that I had to search the person. So section 50 has to be taken into consideration.
Yes.
Now we will
Yes.
now we will come to PW 8, Your Lordship.
PW 8.
Yes, Your
Who
Lordship.
supported the
Who
prosecution?
is the investigating officer and the only person other than the informant who is supporting the case of the prosecution.
IU. ठीक है. Come to IU.
On 7/10/1995, I was SI attached to Nayagarh PS. On that day at about 5:30 a.m. from Nayagarh bus stand, ASI Ramesh Chandra Mandi, PW1, Your Lordship, sent a written report to IAC Nayagarh through Constable 344 Sudham Charan Naik, PW2, who has again turned hostile.
PW2.
Yes, Your Lordship, being their witness only. As report of a cognizable case under section 20 of NDPS and 47A of the Odisha Excise Act, the IAC registered Nayagarh PS case number 282 of 1995 and directed to take up investigation. This is the report of RC Mahanti marked as Exhibit 1 and this is the endorsement of IAC BP Das, who has not been examined. Marked as 1/2 with his signature. I am acquainted with his handwriting and signature of IAC. IAC noted this fact in station diary number 139 dated 7/10/1995. Your Lordship may note that. Why I am stressing on that? Because I also found out judgments that say that if whatever has search, seizure or gadgeted officer formalities have not been mentioned in the FIR, then that also puts a doubt on the veracity of the case of the prosecution. And I have judgments to that effect. On one hand, he says that he entered it as a station diary. But first he says that was only considered as the first information report. And informed the NDPS case to his immediate superior authority, SP Nayagarh. But he has not been brought into
Yes.
and sent extract of the said station diary entry to me. I was present at the time of making station diary entry and dispatch of the extract of the same by the IAC Nayagarh. I came to Nayagarh bus stand along with BP Das IAC Nayagarh. I found the accused was standing in a bus stand with
What
a
is his
bag
name? He is Mahapatra. Huh? Yes, yes.
and was detained by the ASI RC Manti along with APR force. I examined PW1 at the spot. I asked the accused his name, to which he had stated that he is Bijay Kumar Sahu, son of Gangadhar Sahu of Bolagad PS. Then I expressed my intention to search his bag and person.
Hmm.
As suspected that some contraband articles were kept in that bag. I also gave him the offer whether he is intended to be searched before a magistrate or before a gazetted officer. He expressed his willingness to be searched before a gazetted officer. Then IAC Nayagarh BP Das gave his identity to the accused, stating that he is inspector of police and gazetted officer. Accused has stated that he has no objection if he will be searched before the IAC, who is a gazetted officer.
This was given in writing,
No,
orally.
no. Or
Orally.
they are saying it orally. They have not recorded any reason as why to he was not being taken to the nearest magistrate. And in the accused statement, he says that he had not been asked about any such thing.
Yes. Okay. Yes. Proceed.
Before effecting search, I gave my personal search to the accused in presence of witness. Then searched the phone bag of the accused MO1 in presence of a gazetted officer and witness. And on search, I found one paper packet containing ganja and 2 bottles of ID liquor. Before effecting the search, I also called 2 independent witnesses, Chobi Behra and one Kalia Behra. This Kalia Behra has not been examined. This Chobi Behra who had been examined, he has again resigned. Then I called one Lochan Sahu.
Then 50 clause 5 is compliant.
Is not
Subsection 5 is compliant. Two witnesses were called for.
Yes, they were called for, but
they are not supported. One of them is not
Yes,
examined, the other one not
Yes,
supported.
yes, Your
That's right.
Yes, Your Lordship. Then I called one Lochan Sahu to come to the spot with weighing instruments to weigh the ganja, on which Lochan Sahu came to the spot and weighed the ganja in presence of the accused and witnesses. It was 425 grams of ganja. I demanded the authority of transporting the contraband NDPS articles to the accused, but he could not produce any. I prepared 2 sample packets, so and so, and were kept in separate paper packet. I sealed all the 3 packets by affixing my personal brass seal, and before the wax seal was prepared in 3 separate white papers containing the signature of witnesses and the ex. The wax seal were kept inside the seal packet. This is the paper packet containing the rest 375 of the ganja marked as MO2. There are 2 bottles containing ID liquor as MO3 and 4. Your Lordship may note that this brass seal has not been marked as MO. This brass seal has not been marked as MO.
Packet is containing so. Bottle containing. Yes.
The MO has not been produced. The brass seal has not been produced.
Brass seal not produced, huh?
No.
Yes.
Your Lordship, I may then directly come to Paris 7, Your Lordship. Because,
7 years.
yes. After sealing the
Brass seal not produced, para 5, huh?
Para 5 and Para 7 also.
Para 5?
And Para 7.
7 also. Okay, 7. Relax, 7.
After sealing the 3 packets of ganja, my personal brass seal was given in the jimma of the witness Lochan Sahu, Your Lordship. PW7. Exhibit 3/1 is the Jimanama executed by him. There are 2 sample packets sent back to the court after examination by the chemical examiner. These are 2 paper slips which contain the signature and the accused witnesses contained as marked MO 6 and 7, Your Lordship. However, in the judgment, Your Lordship, that is not there. After making seizure of the ganja and liquor, I handed over the 3 packets of ganja and 2 bottles of liquor in the gym of IAC to keep it in the PS Malkhana till its production before the SDGM Nayagarh. So till now, Your Lordship, the liquor has not been measured. It
That's
is
right.
liquor that is there, but what is the, as in what is the quantity of liquor that is not measured, Your Lordship. I arrested the accused on 7/10/1995. I submitted the charge sheet against the accused under section 23 of the NDPS Act and 47A of the Bihar and Odisha Excise Act, Your Lordship. However, it should be section. Thereafter, the accused has been convicted of section 20, however. I have sent the detailed report about the detection of this case regarding search, recovery, seizure, and arrest of the accused to my superior authority, SP Nayagarh, Your Lordship. I have examined Constable 355 Bibu Prasad Mahapatra, PW4, who has, again, their witness, Your Lordship. Their witness, he has turned hostile. He has stated before me that near the bus stand, they found a man standing holding a foam bag, and when he saw the police, he behaved suspiciously, and so the SI Mohanty Babu interrogated him and disclosed his name and address, and thereafter Mohanty Babu searched the bag in presence of Kalia and Madhav Sahu and recovered one paper pudia containing ganja and 2 bottles of ID liquor and asked him to produce the license. They were guarded by the accused, and thereafter PW1 sent a report to the IAC through Constable 344. After some time, the SI GR Mahapatra and IAC reached there and they searched the bag and recovered ganja and liquor and weighed the ganja and thereafter sealed the same after seizure and preparation of the seizure list. Thereafter again he speaks about PW5, Your Lordship, but PW5 is also their witness, but who has not supported their case.
Who is PW5?
PW5 is Ponchu Penthoi.
Who is he? Constable.
Yes, Your Lordship.
Okay, I understood now. Let us see who is Kalu? Kalu PW?
Your Lordship. Kalia Behra alias Kalu has not been examined only.
Who is examined then? Another one.
Examined, Your Lordship, Chabbi Behra is PW6.
PW6 is the witness, independent witness.
Yes, Your Lordship.
And let us see PW2 what he says.
Your Lordship is talking about
PW2.
PW2, Your Lordship. PW2 is Sudam Charan Naik. He is a constable, Your Lordship. I know the accused who is in dock on 7/10/1995. I was present. I was in my present post on 6/10/1995 night. I was detailed to perform. I was directed to perform anti-dacoity patrol duty along with PW1 and others. And we returned to Nayagarh in the early morning. We reached Nayagarh bus stand at about 5 a.m. on 7/10. The PW1 gave a written report to me and hand over the same to the IAC Nayagarh, and accordingly I handed over the same to the IAC Nayagarh.
He's not, he has supported.
Yes, Your Lordship.
He is supported.
Yes, Your Lordship. But he does not say anything about.
He only
You are supposed to
taken and
hand over
given.
that
That's all.
Yes, Your Lordship.
Exhibit
Yes, Your
one.
Lordship.
Supported.
Thereafter, PW3 is also there. There are other witnesses also who are part of the investigating.
Then PW3 also
Yes,
supported.
yes. PW3 has not supported, Your Lordship.
You see,
He has supported.
they have been examined for
They have
limited
not-
purpose. For the
They have
purpose,
been examined for a particular purpose and they
suppose they
supported
have
that.
said that it's not necessary that they should be examined everything.
No, Your Lordship, I agree on that. But they should state something that is.
Why should they say? And the prosecution is
Your
very
Lordship-
satisfied with PW1.
No, Your Lordship, why I'm saying he has not been declared hostile. So that is why his statement should be accepted, because he is saying, but I had not seen ganja inside it.
Where is
PW2, parrot 2, last line, Your Lordship.
okay, then it's all right. Then, where is that?
PW2, I know the accused in the dock on 7/10/1995. I was attached to Nayagarh
Para
Police.
2.
Yes, Your Lordship, parrot 2. Para 1, he says a bag was kept on the ground and I was standing near
talking
him.
about PW2, na?
PW3, PW3,
huh?
parrot 2, Your Lordship.
Para 2 years, see.
The PW1 told me that there is ganja inside MO1 and I would become a witness to that. But I had not seen ganja inside it.
Yes, that's very important. PW3, PW3, 3, not seen ganja. ठीक है. Yeah.
Thereafter, your lordship may come to PW4, who is again a constable.
What does he say?
I know the accused in the dock. About more than 2 years back, one day at 5 a.m., we reached Nayagarh bus stand after performing anti-dacoity patrol duty. At that time, one ORT bus came and stopped there. The PW1 went inside the bus to detect the transportation of contraband articles. He presents a completely different story. He came out from that bus with a bag, and this accused in dock was found standing near that bus.
Okay, this is a different story. PW4. PW. He went and got that bag.
Yes, I was
Whether
there
he
at the
was,
bus stand.
no, whether it was this accused was holding that bag, where from he got?
It is a different story altogether. There is no corroboration.
You are your own witness, madam.
Maybe, but for that is only a declared hostile.
Your lordship,
And
nowhere,
that person has not been corroborated by any of the other witnesses.
no other witnesses are saying there were no ganja at all, and nowhere has neither the
No, the
informant
other
nor
person
the
in
investigating
PW3 says
authorities
he
are
has seen
saying
it.
Okay, I understood. Next.
that I was holding that bag.
Let us see PW5. Who is he?
PW5 is Pentha, your lordship. Again, he is an independent witness. So he says, your lordship, I know the accused. I was in my present post. On that 5 a.m., that day 5 a.m., we reached Nayagarh bus stand after performing patrolling duty. After some time, I went to PW1 on his call and found that this accused was standing near him, and a bag was kept in between them. He told us to take the accused and MO1 to Nayagarh PS. Your lordship may note this. Accordingly, we took the accused to the PS.
He is also a police.
He is also in police, your lordship. Part of that anti-decoy.
Part of the team.
Yes, your lordship.
Yes.
Now, your lordship, PW6 and 7 are not police authorities, your lordship. They are independent.
Who is he?
He's
Independent.
Chabi Behra.
Chabi Behra, who was one of the witness.
Oh, wait.
50 clause 5.
Yes, your lordship.
Okay. He is not supposed.
No. I own a pan shop at Nayagarh bus stand since last 4 years. My shop remains open day and night. More than 2 years and 6 months back, one day morning at 5 a.m., the PW1 came to me and took my signature on paper. I do not know the accused in the
This is the usual answer.
usual answer.
Almost every
Yes.
case.
And Lochan Sao.
Let us see 6.
Lochan Sao is, I do not know the accused who in the dock. About 2 years back, once I was called to Nayagarh PS where the police took my signature on a paper.
Who is he? Lochan?
Lochan Sao is important because he had
Jimmadar.
Jimmanama of the brass seal, your lordship. That is why his evidence is to be taken into consideration.
7. Jimma. Brazil Jiman. What does he say?
I do not know the accused who is in the dock. About 2 years back, once I was called to Nayagarh PS where the police took my signature in a paper, but I do not know anything about this case. This is my signature marked as 2/3 on paper. And
Let us see now 57. What is it? 55, na?
yes, your lordship.
55 or 57.
55, Your Lordship, the brass seal is nowhere to be found. The MO1 is bag, MO2 is ganja, MO3 and 4 are bottles, MO6 and 7 are paper slips, Your Lordship. So the brass seal has not been produced at all.
That is again approved by para 5 and 7 of PW 8, huh?
Yes, Your Lordship.
PW
8.
PW 8 and PW 7
Yes, Your
and
Lordship.
PW 7.
PW7.
Brass seal is not.
Yes, Your Lordship. And to the effect.
Yes. Yes, madam. She has raised basically 5 points.
Yes, sir.
First point is the gazetted officer, the DAS.
Search and
Thus,
searches. He has not been examined.
He has not been examined. Secondly, the brass seal is not produced.
Right.
That is apparent from PW 8 statement para 5 and 7 and PW 7. Third is the liquor bottle were not measured. The quantity is not measured. Second is the two witnesses to section 50 clause 5. One of them is examined, the other one was not examined. The one who was examined had tried hostile. 5 is the official witness, your own witness, that is PW 4 and 5, narrates completely different story. These are the 5 points. Meet. You have written note.
Yes, Your Lordship.
You-
Only I've, Your Lordship, can I file it by tomorrow because I need to compile the judgment?
No, just you have now seen the Supreme Court judgment now.
Yes, Your
Same day I want to do it.
Your Lordship, in
I don't
court
want to
today.
reserve judgment. It is getting. What I'll do is before lunch, if I'll hear 5-6 matters, I'll do it
Your Lordship,
before lunch only.
Your Lordship, then I'll take the pen and give it to Your Lordship. I just add the citations and give it to Your Lordship.
You give it to 3.
Yes, Your Lordship.
Yes. Yes, madam.
Let us-
The what happens? The one more problem is once I hear it and I reserve, I have to read once again to
Once
recall,
again. Yes.
reconnect. So that is a big problem. So it's better that you do it. Yes. Yes, madam.
Let her place whatever judgment she wants to place, I'll answer.
3 o'clock.
3 o'clock again, Your Lordship.
तो witness निकाल देना ठीक है okay
Your Lordship,
Yes. 2 o'clock no
2 o'clock will be better.
these five issues which she has
Yes.
highlighted you just
Item 8. Item 6, my lord, I was just little bit late.
next week I have adjourned yes
Item 8.
I've started hearing next week
Tuesday.
yes yes sir
After 8 after launch take care sir.
ହଁ ଠିକ ଅଛି no problem ପଢିଛନ୍ତି 2000 ready
After launch.
are you ready or next Tuesday ରଖିଦେବି
Next week is
Tuesday ରଖିଦିଅନ୍ତୁ
because of section ପାଖରେ ନାହିଁ pen drive ନବା ପାଇଁ that is my problem.
the Tuesday ରଖୁଛି ଆପଣ ନେଇଯାଆନ୍ତୁ ବର୍ତ୍ତମାନ ଠିକ ଅଛି and get a written note small written okay
Item 6 can after launch.
no Tuesday yes next week okay
Item 10.
adjourn କରିବ list ରହିବ yes 10 yes sir
May I please, Your Lordship, here the present appellant convicted for offence under section 310 of SC/ST Act
file
and 325 of IPC.
325
325 million. But 3 SC/ST Act is concerned, here the conviction is for 2 years and fine of rupees 1,000 rupees, no separate sentence for 325 of IPC matter.
no separate sentence
No separate sentence.
okay
But 3 SC/ST Act is concerned, my lord. Your Lordship, kindly have a glance at the charge, my lord. Second charge.
charge huh
Charge.
okay
That the two person face trial, my lord. Out of them, petitioner, the second accused was acquitted from all the charges, my lord. The
And,
present appellant was
this
not.
appellant is only convicted
The present appellant is only
Okay.
convicted.
Sujit Behra
Sujit Behra.
okay
Manoj Mishra acquitted from the charges.
yes
So second charge is concerned that you on
let us see
second day-
charge first no let us
This is
see.
case 38 of the
offense under section 3
325 of IPC.
31X
31X
31X SC ST and read with section 325. Sentence is
Sentence is 2 years and 1,000 rupees fine for SC state and no separate sentence for people.
plus 1,000. 1,000. ठीक है default
Default, my lord, 6 months.
6 month.
2 months.
Default, 2 months. Further array for 2 months.
ठीक है charge.
Page 30.
Yes, charge is
Concerned with my lord, for 3 SC status concerned. 25 is a subsequent.
yes, no.
Second, that you on the same day, time and place, not being a member of scheduled caste or scheduled tribe, intentionally insulted Krishna Chandra Digal in the injured manner, a member of scheduled caste by assaulting him in a public place within a public view. This is for 3(1) of SC state. Your lordship kindly now come to evidence of witnesses. So for evidence of witnesses are concerned.
Which witness? Who is the victim? Victim
Victim PW2, my lord.
PW2.
2. 7 witnesses examined, my lord. Out of them, PW1 is the informant, father of the victim, my lord.
PW1 informant.
Informant, father of the victim.
Informant.
Father of the victim.
Father of PW2.
2.
Father of
PW2 is the victim.
victim.
PW3 and for here the college occurred in a college and victim is a student, my lord. 3 and 4 turn hostile, they are students, my lord. 5 is supporting prosecution case.
PW3 and
4
hostile.
hostile, my lord. 5 is supporting prosecution case. 6 is the doctor. 7 is the IO.
PW5 independent witness.
Another student, my lord.
Okay. PW6 is doctor.
Doctor. PW7 is the IO.
And PW7 is
IO, my lord.
IO.
So far, PW2 is concerned that injured. I am placing his.
Let us see PW2 first.
My lord. PW2, my lord, that I am placing.
Yes.
That is page 43. On 29 November, I was a student of AMC Society College, Tikavali, in +2 second year arts. On that day, myself, Jagannath Khora, Abdul Pradhan, Pramod Malik, Ranjit Nayak were sitting on veranda waiting to go to economic classroom. The accused persons came to me. They told me to accompany them. I refused to accompany them. Sujit Behra dragged me to about 10 meters from the place of sitting. Sujit Behra assaulted me by means of bamboo finger on my scapula. I tried to fade away from the grip of Sujit Behra. Sujit Behra dealt finger blow on my right leg. I fell down as I sustained fracture injury on my right leg. Manoj Mishra was insisting Sujit Behra by saying so and so, and thereafter both the accused persons pressed the bamboo finger on my neck. I shouted, whereafter Jagannath Khora, Pramod Malik, Abdul Pradhan and others came running to me. The accused person left the place. They shifted me to Tikavali Hospital. I was hospitalized for 3 months. On the cross examination, on the next day of the occurrence, police came to hospital. It is notified. I have named Manoj Mishra to come to college veranda and also asked me to accompany him. He is co-accused. It is not a fact that I have not stated to police that Sujit Behra dragged me to about 10 meters from my sitting place. It is not a fact that I have not specifically stated the police babu that Manoj Mishra was saying Pana dash. It is not a fact that I have not stated to police that both the accused persons pressed bamboo finger on my neck. I have not personally gone to inform the lecturer about incident. Vishnu Charan Ratha, Gobind Chandra Ponda.
Yes, I read it. PW1.
Here, my lord, that Siddhartha Das, Vishnu Charan Ratha and Narendra Digal have witnessed the occurrence from a distance of 10
They have not been examined.
None of the
I don't understand.
So far, PW5 is concerned.
No, PW1 reading.
PW1, father of the post occurrence witness, so far his evidence is concerned, that is not that relevant, my lord. So far,
what is the evidence that he is a Pana?
my son Krishna Chandra Digal is a student of Tikavali Academic College. On that day, he was a student of second year arts. On that day, at 11 a.m., Kamaraju Khora, Jagannath Khora.
He narrated every
My lord.
story, then he informed.
That is he belongs to Pananga, that the present, that Jagannath Mishra belongs to Brahmin and present appellant is Chosa.
No, who has said that?
That
Pedal one.
Fidel one said that. Any
Point
certificate,
number 4. Para 4.
any certificate exhibited?
no certificate not exhibited.
Hmm?
That here, my lord, that is no my submission, my lord. That is no public view. That to press that I also kindly turn to PW 5. 2 witnesses are there. PW 2 and 5. 3 for turn hostile. PW 5, your lordship. How what is the evidence there? That he assaulted. There is no evidence that being a member of scheduled caste he assaulted first instance. Second is that there is no public view. Public maybe a public place, but
No,
not.
wait, come to the real point. Real
Well-
point is whether he is a scheduled caste, what is the evidence?
So far, scheduled caste evidence is concerned, that is only they have stated. And
Stated will not do unless.
no,
it is
authorized
established.
there is no such evidence there.
Who is IO? Let us come to IO.
I hope PW 7. On that day at 4 p.m. PW presented to me to police station already. There I drew formal affair. I visited this spot college. I examined PW 3, 4, 5 and I see the X-ray.
Your lordship, regarding the caste, kindly see the question number 12, your lordship. Question number 12 in accused. In accused
Number 12
statement.
of accused statement.
Yes, your lordship.
Huh? Question number 12.
Page number.
Yes.
Page
Hmm.
number 65.
It
and
transfers from the evidence of PW1 and PW2.
Yes, it transfer from
PW1 and 2.
belongs to a caste and Manoj Mishra belong to Brahmin caste and you belong to Chausa caste. What have you got to say? Yes.
That's not the issue. It is the prosecution who has to establish.
Yes, but he admitted, your lordship.
Who is?
या हाँ लेकिन आंसर था हाँ जैसे जानी चीज जैसे ये कास्ट
But you have to establish. You can't, merely. Where is the first you establish, then you put it. Where have you established?
Yes, sir. But
Where have you established? You don't bring any evidence and straight away put it.
no.
Where is the evidence that you have to establish? Because this is, the IO should have taken efforts.
Regarding the document.
Document.
Yes, sir.
That's the very important aspect
Right.
in these kind of matters. And these are the scholar students.
Yes, sir.
Yes.
That's about public view is concerned, my lord, that you also kindly turn to evidence of PW 5.
Public views, they see the
Outside of the
PW2
gate
says
My lord.
it has happened before so many X, Y, Z and all. Merely because they are not examined, that doesn't mean that they were not there. What is the question you have put? This has been done in the college premises, and the
That
PW2 says so many people were there.
My lord. Not
Merely
every
because they are
exam.
not examined doesn't mean that they are not there. They were not there.
And so far PW 5 is concerned, he said no one is there.
Let us see files.
That's it. PW 5. That is page 50.
Yes.
On ETA, I was myself, PW3, PW2 and other were in classroom scheduled to held on economic class. It was 10:30 a.m. On that day, 10:30 a.m. absence accused Sujit Behra called Krishna Chandra Digal from veranda of the room. Both went ahead. Myself went to urinary. I had alarm of PW2. I went to him. I saw the accused Sujit Behra holding a stick standing near PW2 and PW2 had already assaulted. PW2 was lying injured on his leg. PW2 was unable to stand. Accused Manoj Mishra was standing near. The occurrence took place inside college campus. The lectures were inside of the office room. I have not seen presence of the
Only the principal. I have not seen the principal.
I have not gone to principal to report the incident. I personally noticed the mark of injury. I have not disclosed the fact to anybody. It is not a fact that an eyewitness.
Yes, he himself was there.
He himself.
Manoj Mishra was there.
And Sujit was also.
Sujit was there. There are so many people were there. Enough.
No, so far PW 5 is concerned, he present after assault. So far assault is concerned, he has not seen the assault. My lord.
Assault is not more important.
He has not uttered any word. The PW2 present
that
after.
he says that he
Only
that
Manoj Kumar
is
Mishra.
correct. Only then insofar as the scolding part is concerned,
Manoj Khan
except
told that-
PW2, there is no one.
No, that he was.
Scolding, yes, scolding person.
That-
Except PW2, because father is also a hearsay.
Yes,
Yes, Your Lordship.
that.
Except that.
Manoj Mishra also acquitted from the charges. That part is already disbelieved by trial court, my lord.
Just see, PW2, you come to PW2. What is the utterances? I fell down.
I felt that.
Last one, I fell down as I sustained fracture injury on my right leg. Manoj Mishra was instigating Surjit Behra saying, who said? Manoj Mishra said.
Yes.
So and so, so on. Thereafter, both the accused persons. Well, Manoj Mishra said this. He has not said.
Yes,
Then SCST goes. Insofar as this witness.
This is concerned, yes, Your Lordship.
तो रह क्या गया?
ताकू एक्टिविटी कर देंगे एक्वेस सिस्टम के
रह क्या गया? कुछ भी नहीं.
in 325 everything is there.
325, no, nothing is, no.
325 everything is there. Even the X-ray and all the doctors say the grievous injury, fracture injury is there. X-ray, so what is it? 325 का पूरा
What is see, this boy, 20 years. See, these are the incident happened in the college. Just see, if you 325, it's all.
only 3195.
He must be just easy working somewhere.
ମାନେ ଆମ ସହିତ କଣ୍ଟାକ୍ଟ ନାହିଁ ଟୋଟାଲି, ଖାଲି ଆମେ ବୁଝିଛୁ ତାଙ୍କ ଅନୁସାରେ ସେ ବଞ୍ଚିଛି ବୋଲି, ମାନେ ଆମ ପାଖରେ ଲେଟର ରିଟର୍ନ ଅନସର୍ଭ ମିଳିଲା।
It's a case of 325. You can't escape out of it. Okay. But the problem, the problem is this young people in the college that did something. If he's working somewhere as a government employee or something, his life is spoiled.
ଆମ ପାଖରେ
94, just see.
Government employee इतने सारे निश्चय ऐसे बोली था। Government employee इतने से कोई compromise करी से था।
30 ବର୍ଷ ହେଇଗଲେ ଭୁଲି ଯାଉଛନ୍ତି, କେସ୍ ନାହିଁ ବୋଲି କହୁଛନ୍ତି, ଆଉ କହି ଦଉଛନ୍ତି, ପୋଲିସ ବାଲି ଯାଇକି ପଚାରିଲା ବେଳେ ସେ କହୁଛନ୍ତି ଆମ ନାଁରେ କେସ୍ ନାହିଁ। ଆମେ ବି କହିଲେ ନାଇଁ ଆଜ୍ଞା କିଛି ତ କେସ୍ ନାହିଁ।
କନଭିକ୍ସନ ହେଲା ପରେ ଯେତେବେଳେ ଆରମ୍ଭ ହବ, then they run around.
ଓଲ୍ଡ କେସ୍ ହେଲା ବେଳକୁ ସେଇ ଟିକେ
Very difficult.
ପିଓ
No, PO तो I'll have to give PO. I'll have to give
नहीं
PO.
प्राइवेट कंपनी है रोसी तार इंस्ट्रक्शन ने अछि
अच्छी.
आगे ता वाइफ कोई भुवनेश्वर रे प्राइवेट कंपनी अछि ए लास्ट देखो सर सबमिशन ऑफ इंस्ट्रक्शन ना देख
So then I'll impose some fine. IPC देना. और है कि क्या है? And the trial court has not imposed any,
सेंटेंस फॉर
अच्छा एसीजी एक्ट ना एसीजी एक्चुअली एसीजी
फ्रैक्चर इंजरी मींस कि dubious or
हाँ. सरप्राइजिंग है, IPC नहीं रखते यार. क्रिमिनल IPC सुन रहे, IPC नहीं. Got it. See, these are and so some sentence has to be imposed. And shall also be liable for fine. Let us see the doctor, what doctor says.
Yes, sir.
It
Middle
was
6.
6. What are the
52
injuries?
52 page.
Injury number 1 is grievous injury.
One. Right the very fracture means small fracture, body stick the assault. And it
What
can
is the what has he used?
Finger,
stick.
Huh?
finger,
Stick.
finger. Finger তো বড় বড় মোটা finger. মারি তা বড় বড় ভাই।
Body তো
We can't convert it to 323 also.
না, grievous হয়েছে।
So, sentence something and give probation. Hmm?
Arrest ବି ତ ହେଇଗଲା ଗୋଟିଏ ଦିନ ନା କଣ?
Hmm?
one day only.
One day only.
One month and 1,000 fine. Okay, and probation.
Probation.
Probation I'll give, but see, it says sentence and as well as the fine. Both the things has to be imposed, and I will give probation. Okay.
All total prosecution evidence disputed by trial court only this assault. And now also only actual assault, all part of that disputed. Presence of Manoj Mishra and press of neck.
No,
all
no,
part.
against
And-
Manoj Mishra, something could have been done in 3A. Manoj Mishra has said everything, and he is convicted under.
Press neck by Thenga, both the accused person, that also disbelief.
যে করেছে সে তাকে সেমিজন যে করে
Ready?
It's that put that in 6 minutes. It will not response, right? And then.
I just after. I'll just come.
That's about this matter earlier. Petitioners are father and son. Main offense is 436. The lordship wanted that probation on the 430. I
yes.
could not get it. I got one Maharashtra edition, but I could not get the copy from AR manual. I searched for it. Here, the actually, if your lordship, because warehouse report is it's not there, I have so better is. But here the allegation is father and son. The father purchased land in the name of his wife near the village of the informant and others. There is the dispute. They refused to give possession, and the dispute continued. Allegation is we, along with 20-30 people in a mini truck, went there, set fire to 2 thatched houses, and threatened them, abused them. No assault. Now, informant is not an eyewitness. In the affair, only the son, name of the son finds place, nickname. Then PW2 is the only person who says one of the persons whose house has been burnt. Now, she says that father and son both lighted the houses, both the 2 houses. Now, and that too in the cross-examination it has come. That is the unfortunate.
I know. Otherwise,
But if your lordship
in
will
chief,
look,
nothing is said.
No.
Cross-examination.
but if your lordship look at PW3 and 5, the co-villages, they have specifically stated that we all were there in the cultivable land because it's a harvesting season. The villagers unitedly they go.
Yes.
This none of the persons, including PW2, they were not present in the village. Only when the fire broke out, we came to the village, saw this accused person living. So exactly if that part is accepted, version of PW3 and 5, that PW2 were neither PW2 nor any of the villages, they were present, and specifically they have said this PW2 was also there in the field along with them. So the version of PW2 may not form the foundation, and on that basis you will accept an accuse.
What is
3 and
Sir,
5.
there are 5 eyewitnesses, and including PW2, whose house has been burnt. I'll just place those evidences as the lordship. May I start with the PW1? I know the accused persons on the dock. I'm a member of Kondha community. You know, so the story goes beyond like this. The accused person purchased a piece of land in the particular village, and since these persons are residing there and he could not get a peaceful possession, that is how this occurrence took place. Now I'll proceed with the PW1. I know the accused persons on the dock. I'm a member of Kondha community. The accused persons are Brahmins. About 2 years and 4 months back, one day about 3 p.m., the accused persons armed with Honda, Kati, etc. came in a mini truck to our village along with 40 to 50 others. The accused persons' names they set fire to the dwelling houses of Thula Mallik and cattle shed of Rama Mallik of our village. The said dwelling houses was completely burnt, but the cattle shed almost completely burnt. The accused persons claim to have been purchased a piece of land in our village. Previously, the said land belongs to the government. We were residing, raising paddy, mandia, etc. on that land. The accused person set fire to the houses in connection with the said land. This version corroborates with the accused statement. Your Lordship. I have lodged a report in writing at Digappondi police station. This is my report at Exhibit 1. So answer. In cross-examination paragraph, he states, at the time of occurrence, I was on my land. My land is
Where are you reading?
Cross-examination paragraph 4, PW1.
Yes.
At that time occurrence, at the time of occurrence, I was on my land. My land is at a distance about half a mile from the houses of Thula Mallik and Rama Mallik. One.
By the time I came,
Rama Mallik. By that time, I came to the house of Rama Mallik and Thula Mallik. I found those houses are burning. My daughter Minnati informed me that houses of Rama Mallik and Thula Mallik were set fire. I rushed to the spot. I have seen Suratha Panigrai and Tuna Panigrai setting fire to the houses of Rama Mallik and Thula Mallik. He identifies the Surat Panigrai who is on the dock and says that the Tuna Panigrai is
first he says that the house is already burning.
probably there are.
And thereafter he says that I saw, once it is burning, where is the question of setting fire?
One house and one cow shed. By the time he comes, the one of the cow shed or the-
Anyway, this is
Yes.
what,
Surat Panigrai lighted a matchstick and set fire to the cattle shed of Rama Malik. This is how he explained that he saw the Surat Panigrai setting fire to the cow shed. Your Lordship. Tuna has not set fire, but he was present with the accused. The mini truck in which the accused person came parked on the rest of the
Surat Panigrai is appellant number 1.
appellant number 1. Yeah. They both were father-son duo.
What is the role of me too, Gyanendra Panigrai?
He was present.
Only present. Has he set the fire?
From the PW1, he has not. Shall just place the 149 is there.
See, now I am looking at this aspect. Suresh Panigrai,
Panigrai lighted a match.
5 years of age at
Yes.
that time, point in
Yes,
time.
sir.
He must be now around, what will be the age?
78.
78.
78.
Okay.
Mm.
We can very well send him PO Act and all we can give because of the age and all. One thing. I'm exploring the
Yes,
possibility.
sir. Yes, sir.
And in so far, let us see the
Pilot,
Gyanendra Panigrai.
2.
before that,
Me too.
Yes, sir.
What is the role attributable to me too?
Yes, sir.
Let us see from all the witnesses.
Yes, sir.
We can think of me too.
And sorry for interruption. First part, he says, I was in the field. I have not seen. My daughter informed me these houses were burnt.
Thereafter,
he-
saw all
if you can
this
say.
is the- this
One
one-
But in the FIR, he doesn't say.
But he in the same time he doesn't say anything. Surat Panigrai and Tuna Sahu are setting fire. He says take this both the name.
In the chief, he says that. In the cross-examination, he differentiate the particular role attributed.
On the cross, all these things are coming.
Yes, sir. So there are
Yes, this is PW1.
PW1.
What PW2 says
PW2.
about Tuna?
Your Lordship, Tula Malik and Rama Malik are the persons whose house has been burnt. And PW2 is the wife of Rama Malik, Your Lordship. I know the accused persons on the dock. They gives the name and identifies them. The accused persons are father and son. I'm a scheduled type member. The accused person do not belong to our community or to a scheduled caste. After 2 years and 4 months back, both the accused persons along with 40 to 50 others armed with Honda, Kati, etc. came to our village in a mini truck. It was about 3 p.m. The accused person and their associate frightened us. We kept indoors, being terrorized. They set fire to our dwelling houses, that is the dwelling house of my husband Ramo. It was
Now in the cross examination, Para 2 says me too set our house,
yes, yes, Lordship.
set fire our house.
I'll just go with the flow. It was completely burnt. They also set fire to the dwelling house of Tula Malik, which was also burnt completely. Those two thatched houses at the outskirts of our village. There is a fallow land and cultivating. The accused person claimed the said land to be there. They have set fire to the house and terrorized us to evict us from that particular land. The land. Your Lordship, there in the cross-examination, as a Lordship.
Cross examination is much more.
Yes, sir.
That's what I said. But
For both the
let her complete notes.
The village consists of houses. At the time of occurrence, some male members were in the present in the village, and some were absent. PW1 was present. PW1 was the just I read it. Then when the accused person came to our village is about 50 feet away from the main road. The main road is at that point about the land which the accused person claimed to be theirs. The mini truck came to the house which was set fire. Accused Mittu set fire to her house. Accused Suratha set fire to Tula's house. The accused person and all those came along with the kept standing there even after setting fire to the houses. They remained there for about 1 hour. All those persons continued to be there till those two houses are completely burnt to ashes. All our belongings kept in that houses are burnt. That's why PW3 years. I do not know accused Mittu Panigrai. I know the other accused who is one Panigrai. I am a member of the scheduled tribe. More than 2 years ago, one day at about noon time, the accused Panigrai along with 50 to 60 others armed with Kartik, Honda, etc. came in a mini truck to our village. They raised a Chamundia on the Podia land near village. We Adivasi people used to raise mandia crops on that particular land. All those persons being so armed marched through the village and exploded 2 bombs. This is the improvisation. Olush. They left the village. On the same day, they also set fire to the dwelling houses of Rama Malik and Tula Malik. Those houses were completely burnt. In cross-examination, he said those persons and Mr. Panikrai were claiming the land on which they raised a Chamundia as their purchased land. I cannot give the names of persons who threw the bomb. The houses of Rama Malik and Tula Malik caught fire due to explosion of the bomb. There are other thatched houses in a row near the houses of Rama Malik and Tula Malik. Rama Malik,
He is indicating first appellant number 1.
yes, one. Rama Malik and Tula Malik were not in the houses. Only thing he said that Rama Malik and Tula Malik were not in the houses, as the family members of those persons were not present in those houses. They have been to their land and it was harvesting season.
That's what I am saying.
No, I'm
They
saying,
Okay, I got the overall this thing. What is your then? How will you get over 1, 2,
no, Your Worship, 1, 2, I'll just place 4 also.
4 also?
Yes. Five. It's not 4 would be relevant. 5 would be relevant. I have been residing in Kumbhajari since my birth. I know the accused persons on the dock. I'm scheduled caste by being Malik. Occurrence took place 2 years and 4 months back. Both accused persons and many others came in a 407 mini truck armed with sword, lathi, etc. to our village. They moved through the village to frighten us. I found that the dwelling houses of Ramu Malik and Tula Malik of our village burning. Those houses were burned to ashes. Malesu informed the incident to the police station. There is a fallow land at the end of the village. We have been enjoyment of that land since the days of our forefather raising crops. The accused person threatened us, claiming to have purchased that land. The land is still in our possession. In cross-examination, he says, on seeing flames in the village, I rushed to the village. Others also came running to the village. By the time we reached the houses were burnt to ashes. The mini truck 407 has already left by the time we arrived. I haven't seen the actual setting of fire. This is what Malana Senior has pointed out. I have been to the land about 8 to 9 a.m. That family members of Tula Malik and Rama Malik had also gone to the lands. They came to the village on getting information of fire.
I was on this.
I was just referring to you're pointing on this one.
Yes.
So PW 1, 2, and 3, they categorically say the particular role attributable by both the appellants as well as the result of those fire. So that is my speech.
Yes.
The background you will has seen.
We
purchased the land.
Why should the
Yes,
PW
I'm
1 and
answering
2
that,
will
Lordship.
not be believed?
With the background, if this evidence is taken up, because I have purchased, I have given defense evidence, that is not the dispute. Asked for the police help, it never happened. And the land,
Can I say?
though I purchased, they have admitted in 2 and 3 that because their consent has not been taken and they were raising some crops, that is the reason they are objecting to. In this background, Millers, some biasness or something, some incident had taken place undisputedly. Pedolu 1 himself nowhere claims that he is an enemy. Though first he says, after got the information that houses have been set to fire. He heard it from her daughter. Thereafter say so and so has done it. Because if the sequence of the statement is taken together, both are totally contrasting each other. Same with PW2. PW2, though specifically says this father and son, they have lighted 2 houses. Now, if all the statements 3 and 5 say they have not seen, they have admitted. But in addition to that, they have said nobody was there in the village. The persons whose houses were burnt, they were also in the field working with us.
Now, where is the specific word they were also in the field? Where is that? So then you doubt PW 1 and 2, the presence
Because
of PW
1 itself is doubtful because he says I was not there. Then he second.
Where from you will get the doubt that PW 2 was not present there in the village?
PW 3.
PW 3, let us see.
PW 3. Cross-examination portion.
Yes.
Para
Para 3.
3,
Yes.
4 lines.
Those person,
There are from the middle lamp fire due to explosion of bomb. There are other thatched houses in a row and the houses of Rama Malik and Tula Malik.
Para 3 you are reading.
Para 3,
Normally,
5 lines
when
after 5 lines.
not in the house.
Rama Malik, Tula Malik were not in those houses. The family members of those two persons were not present in the houses. They had been to their lands as it was harvesting season.
PW, Rama Malik is PW?
They have not been
PW2.
examined.
Who is PW?
No, PW2 is the wife.
Wife of the Ramamali.
Wife of Rama. They have not been.
Family members are not there.
Family member.
Yes, he says neither the family members because all of them were there in the field because it was
So
harvesting
therefore,
season.
you are doubting the very presence of PW2.
Yes,
where-
only their no, attraction was only a fire broke out. All of them were in the field. They came back. Maybe 40 persons along with those persons spreading.
Nobody has seen, according to you.
Who has actually lighted? If that part goes, then some relief can be.
This is one part. Next,
Same with same PW5.
5, General C5.
So,
W1, 2 would be very relevant.
No. He's saying the
Yes, sir.
very presence of, see, insofar as PW1 is concerned,
Yes,
in the cross-examination, he says that I heard everything, it was
In
burned
the
by, from my daughter.
Yes, sir.
And thereafter he says, it was burning.
Yes.
Thereafter he
Huh.
says that I saw their lighting and all. This
There
is
are-
one.
and that
No,
part
no,
was
I'll
not there in
explain
the
that.
affairs.
Yes.
I'll explain that. In the chief examination, he said that he was in the field. He heard that the fire has been set to some houses. He has been to the spot. Then in the cross examination, he says, while he reached the place of occurrence, he saw that the Surat Panigrai
I know that,
lights
but see, therefore, what he says is, his versions are bit contradictory. So therefore, it can be doubted. But in so far as 2 is concerned, it's very specific.
very specific.
But 2 is doubting because of 3 and 5.
Because
3 and 5 says that all the entire family members were there in the field.
See, there are two.
2's presence is also doubtful. That's what is clear.
May not be, Your Lordship. He says Rama Malik and Tula Malik were in the field, assuming for a
Family
second.
members.
Your Lordship, Rama Malik and Tula Malik were in the field, and PW3, according to the London Council, Your Lordship, he was not present. So since he was not present at the particular, how can he say whether my family members are there at the house or not?
Let us see for PW5 where does he
Yes.
say
Yes.
that family members are.
Para 2, cross-examination.
Yes.
On seeing
think
flames
the-
in the village, I rushed to the village. Others also came running to the village. By the time we reached the house, houses were burnt to ashes. The mini truck 407 has already left by the time we arrived. I had not seen the actual setting of fire. I had been to the land at about 8 to 9 a.m. The family members of Tula Malik and Ram Malik had also gone to the lands and they came to the village on getting information of fire.
So PW, I'll again repeat, Your Lordship. PW1. There are 2 houses which are burnt. One of the house.
Your case is revolving around 1 and 2.
1 and 2.
1 and 2. Well, let us see 1 again.
1 again. Just reread the paragraph 1, 2, and 4. I know the accused person is the dog. I am a member of so and so, so and so, and so.
Forget,
About-
come to the accused person's claim.
Your Lordship, about 2 years, a month, 4 months back, one day at about 3 p.m., the accused person armed with Khanda Kati came in a mini truck to the village along with 40 to 50 others. The accused persons named set fire to the dwelling house of Tula Malik and cattle shed of Rama Malik of our village. The said dwelling houses was completely burnt and the cattle shed almost completely burnt. The accused persons claimed to have purchased a piece of land in the village previously. The said land was belonged to the government. We were raising paddy, mandi, etc. on that land. The accused person set fire to the houses in connection with the said land. I've lodged a report on so-and-so. Prosecutor, he says, at the time of occurrence, I was on my land. My land is at a distance about half a mile from the houses of Tula Malik and Rama Malik. By the time I came to the houses of Rama Malik and
Underline this.
I found
By the time I came to the houses of Ram Malik and Tula Malik,
houses were burning.
I found those houses were already burning.
Burning.
Already burned.
My daughter,
Meaning,
in
Minati or
the
whatever,
houses of Rama Malik and
inform me
Tula
that
Malik
house of Rama Malik and so on.
I rushed to this.
Where set fire?
Where set fire?
Already fire
Yes, sir.
and burning. These are 2 very important sentences.
Seen Surat.
Then I rushed to the spot.
Yes, I have seen.
I have
Surat
seen
Panigrai
Surat
and
Panigrai and
Surat Panigrai
setting the fire.
to the
If
house
it was
of
already
Rama
set
Malik.
fire, it was already burning.
Yes, Lord.
So where was the occasion for these two witnesses, these two accused to again set fire?
Lordship, that should have been explained in the cross examination that how many houses are there. We do not know how many houses are there. There
It's
were
there.
thatched houses.
In the evidence, it's there, a row of houses that the witness has.
I have seen so.
Yes, Your Lordship.
identify this room.
Had it in a one room or something, Your Lordship?
Is on the dock. They say that Tunna Panigrahi.
Then he explained that Surat Panigrahi lighted a matchstick and set
No,
fire to the
again in
cathedral
the
of
bracket
Rama
what is
Malik,
written? Tunna Panigrahi is setting fire.
to the houses
The
of
houses
Rama
of
Malik
Rama.
and Puna Malik.
He identifies
Surat Panigrahi.
who is on the dock and
And
says that
Tunna
Tunna Panigrahi
on the
is
dock.
not on the dock.
He could not identify, Your Lordship. Could not identify.
But in the affair,
But he says that I couldn't identify. But in the same time, he says that the Tunna Panigrahi was setting fire
He
in the
said
previous sentence.
the previous sentence. Then he
For the purpose of seeing setting fire, he knows Tunna.
I concede to that also.
Then,
Again, I'll
then
for
the
PW
entire thing is getting doubtful.
regard,
Because see, once he's not able to identify Tunna Panigrahi in the dock. At the
Yes,
same time, in the preceding line, he said that I saw Tunna Panigrahi was doing this, Sarathi is doing that. So Tunna is gone
Tunna is not for
Tunna for the purpose of one.
BW1, Your Lordship.
PW1 gone.
Surat Panigrahi lighted a matchstick and set fire to the cathedral of Rama Malik.
Yes.
Then he explains as well. Tuna has not set fire, but he was present with the accused. He volunteers.
Hmm.
So he said, then I will take your lordship to the PW2.
Let us see the PW2. Let us see PW2.
PW2.
PW2 is a very important witness for you.
PW2, who is the wife of the victim. Your Lordship. About 2 and 4 months back, both the accused persons, along with 40 to 50 others, armed with Khanda Kati, etc., came to our village in a mini truck.
You are
It
reading
was
two?
about
You are reading two?
PW2. Your Lordship.
Yes.
3 lines from the top. Your Lordship.
Hmm.
About 2 years and 4 months back, both the accused persons, along with 40 to 50 others, armed with Khanda Kati, etc., came to our village in a mini truck. It was about 3 p.m. The accused persons and their associates frightened us. We kept indoors being terrorized. They set fire to our dwelling houses, that is the dwelling houses of my husband Ramo. It was completely burned. They also set fire to the dwelling houses of Tura Malik, which was also completely burned completely. Those two were thatched houses. At the outskirts of our village, there is fallow land which are cultivating. The accused person claimed the said land to be theirs. They have set fire to the house and terrorized us to evict us from that particular land.
Yes.
In the cross-examination, the village consists of 20 houses. At the time of occurrence, some male members were in the house, in the village, and some were absent. PW1 was present. When the accused person came to our village, our village is about 50 plus away from the main road. The main road is at that point
Our village is about 50 plus feet away
away
from the
main road.
main
The
road.
main road
The
at
main
that
road
point,
at the point.
about the land in which the accused person claimed to be there. The mini truck came up to the house which was set fire. Accused Mittu set fire to our house. Accused Suratha set fire to Tula's house. This is corroborating with the PW1. The accused person and all those came along with kept standing there even after setting fire to those houses. They remained there for about about an hour. All those persons continued to be there till those two houses were completely burned to ashes. All our belongings kept in the houses were burned.
Like, see, it's not a fact that the village cutting and setting out the crop raised by the accused persons in that land and got instituted the another house also people. So it is not a fact that the accused persons had not set fire. Let us come to the IO.
Chief
IO
Milos, Chief, your Lordship has seen. First, he says, when they came out of fear, I went inside the house. They set fire the house.
He says,
Kati, etc. 5 lines. Persons and their associates frightened us. We kept indoors being terrorized. They set fire to our dwelling house. She was inside, as per her version.
we kept
That
indoors.
will make the things worse in fact.
We terrorized.
And the accused person set fire. IO Millards, nothing much. So that part is
right in that. Is IO, let us see IO. PW 6. What does he say? Regarding PW 2.
PW6 is the IOL.
Print out from evidence.
Nothing much in the IO's evidence.
He did not say much.
That much.
Prosecution part is that
Yes, yes.
no way helpful. Only thing is, whereabouts report is not there, neither with me nor with them. So this is the in between way. Somehow this is not a case where much effort has to be given.
Tuna is to be acquitted.
Pardon?
Tuna. Me too.
Me too. PW state that she has seen setting.
That may not will solve for the purpose. The father may not be there or not. We don't know. So 1 year or may released on probation. 2 years.
Tuna's involvement is creating serious doubt.
Only PW. I'm just pointing out. I'm not.
But he-
I'm not on the way.
Why not? Why we discard the evidence of the other witnesses? Why should we discard?
The only thing the PW1 states that he could not identify Tuna in the dog. PW, there is nothing.
But he says that Puna has done it.
He has done it, but
Set fire, he has seen it. So
the cross-examination.
that kind of evidence, if you want to give benefit of doubt, you can. If you don't want to give, you don't want to give. That's a different story altogether. I am finding out a way to give some benefit of doubt.
3 and 5% that can help
See,
me.
the idea is, one is 55 years that time.
Yes.
He might be 78 and all.
23 years.
Whereabouts are not known. Let us see the ground reality.
Yes.
What happens. But at the same time, acquitting is not possible. So,
23 years by itself is a reason to not to send them even if.
But he must be 23 that time. He must be in 50s.
The only problem is
56.
the punishment entailed in the 436. That is
Sentence is, what is the sentence?
life.
No, there is no
They're
life.
not
436. Otherwise, PO Act won't apply.
What is the sentence given?
Sentences arrive for 1 year and 2 years for 506, 1 year, 2 years and to pay fine for 436, 2 years. That is the reason period may not be there, 3 years automatically.
What is undergone period?
Shall be punished with the imprisonment for life.
Let us see. Let us just see, madam, undergone period, if you can get something.
Undergone period.
Let us see. File form, nikalo bhaiya, file form. When these people.
No, the order sheet is not there. Initial order sheet is not there. They were arrested on 17/11, remanded on 18/11/99, but thereafter
They were arrested on 17/11.
17?
11.
11/99.
17. And proceedings, just see the proceedings are there. 17/11/99.
The order sheet of
99. And now see the order sheets.
These are ଦୁଇ মানে এটা হাইকোর্ট রে during trial, huh? The conviction.
conviction.
We need a conviction.
Either conviction, after conviction, there is one after conviction. Conviction. That's what we will do it after conviction. Order sheet arrange.
There are high court judgments of different high court.
Hmm?
There are different high court judgments. One is of Allahabad High Court. In 436, they have been granted with benefit of Section 4.
Huh?
Act.
Benefit of Section 4.
Yes.
Can you give those judgments?
Pardon? Your Worship?
Can you give
Yes,
those
I'm
judgments?
just sending.
Allahabad High Court and
One.
one
The one I'm reading is with Allahabad High Court. It's a 24 judgment only. The recent one, I'll say.
give that judgment
Yes.
why to
Yes.
labor hard.
Yes.
Huh?
Yes.
Why labor hard? We will give that judgment to me. Huh? 436. Huh?
436 only. Yes.
I'll give that benefit. Well, event over this is taken by 99. Whereabout are not known. Even if you convict them, you can't search them.
I've shared the judgment.
You send the judgment, you get the judgment.
Print back.
उसमें दे देना।
What it is.
यहाँ पे PO लिखिए। ठीक है। हाँ हाँ उसमें बैठे 13 और की उसमें 13 yes Mr. Vishal you 13 huh? Yes. What is this matter?
My lords, the appellants, they are convicted under section 147, 149, 341, 323. Initially, the charge sheet was filed under offense under section 147, 341, 323, 149 IPC.
What is this? Sentence is
6 months of rigorous imprisonment, which has to be concurrently flew with section 323 and 341.
Eyewitness?
There are total 5 eyewitness. There's no independent eyewitness.
Only who is injured? Who is injured?
13.
13.
13.
Who is injured?
12.
12. Okay.
I'm so sorry.
Okay, 12. Huh? Okay. Okay. Who is injured? Sir?
The PW1 and PW4.
PW1.
My lords.
2 injured, huh?
2 injured.
Let us see PW1.
My lords.
Let's see. And doctor.
There are 3 informants who have filed the FIR. PW3 is a medical officer. PW5 is the investigating officer.
Yes. Let us see PW1. What is the name of this?
PW1.
How many of you are there?
5 accused, your lordship.
5. Young. Yes.
The PW1 is Srimati. Anyways, her statement is that I know the accused persons. I know accused Dayanand and Jubaraj who are in the dock. I also know the absentee accused persons Bikram, Bihari, Dayamaya, They belong to our village. I am Harijan, being Ganda by caste. None of the accused person except accused Jubaraj is a member of SC or ST. Accused Jubaraj Malik, being Krutta by caste, is a member of scheduled caste. It's very important, Your Lordship. The occurrence took place about 1 year back in our village during morning time. In the morning, myself, along with Banita Suna, Pahati Bag, and others, others of Gandapada went to fetch water from the tube well situated near the village club because tube well in our pada was out of order. While we were pumping out water from the tube well, all the accused persons came there. Accused Bikram abused and threatened, saying as to why women belonging to Ganda caste were taking water from their tube well. All of them physically pushed us, whereas accused Bikram assaulted me and my companions with a bamboo stick. I sustained injuries. Banita Suna also sustained injuries due to assault by accused Bikram. All of us went to the police station where a
Vikram has given the blow.
yes, Your Lord.
Only.
Yes.
Yes.
Where a report was lodged, I was medically examined on police requisition, cross-examination. The accused persons reside in a different pada, the tube well from which we were taking.
You have been acquitted for offense under
Section 3.
Yes, yes.
Section 3.
only 323,
Only
Ye-
323 and
and-
341.
341. And
149 is also.
oh, it's all right. But see, now the allegation is only Vikram has given the
Blow.
he assaulted.
For that reason, I said 149 is there.
That's right. I know. I understand. I'm finding
My
out a
lord.
way to get out of that.
I'm just bringing the
Vikram has assaulted,
yes,
and
Your-
all of these people were present there.
yes, Your Lord.
Okay. This is the PW1.
It is
Let
the
us see
case of the prosecution.
yes. Let us see PW2.
My lord,
Let us
there's some
understand the
certain
case and we'll
aspect, Your
proceed.
Lordship. What I want to say is that initially, when the FIR was filed, in the FIR, the complainant says there were 2 persons. Subsequently, while filing of the FIR, I don't know how 5 persons were implicated. If Your Lordship will see the FIR, they say ଦି ଜଣ ଥିଲେ ଉଭୟ ଜଣ ଆସିଲେ ପାଟୁଣ୍ଡ କଲେ.
Sure.
But I don't know in FIR how 5
The informant is PW1.
the informant is PW1, PW2, and PW4.
In the FIR, sir, there are 5 named accused persons. So it won't be right to say that there are only 2 accused persons. in the
See,
FIR.
I just want
Yes,
to
right.
get a
Yes, Your
overall
Lord.
idea.
I will show it.
Hmm.
From their own statement, I will show it. How they say that there were 2 persons only. Now, if Your Lordship want to see the PW2 statement, and one aspect, Your Lordship, may kindly see the PW1's cross-examination for others. They say, I am illiterate. It is not a fact that the contents of the report scribed at the police station were not read over and explained to us.
It is not a fact.
What?
Hmm.
That means he says here, it has been read over to her.
Okay,
Yes.
it's all
Yes.
right. All right.
Yes.
And the PW2 also says Bikram assaulted.
Yes,
Lalita? Yes.
they're in
These
tandem.
people
But
were
the
there.
important aspect is that paragraph 2, Your Lordship, that day, as the tube well of our locality was out of order, myself along with PW1, Bonita Suna, Gharjugi, Kunjalata of our pada. That means total of 5 women were present at that point of time when they were pumping out water from the tube well. But only 3
No, no.
persons have come forward.
No, only 3
and-
persons are there.
Kindly read the entire thing.
Along
No,
with
the 5 accused,
one.
five
Myself
accused
one.
persons.
Myself 1.
Huh.
There are 5 accused persons.
No, no,
Five
she
convicted.
said there are 3 victims.
3 victims, there are total
3 victim, 1, 2, and 3.
1 to 1.
Victim.
Yes.
But one has said Vikram has assaulted.
He is
2 has also said Vikram has assaulted.
Yeah.
And
No.
3 is
Yeah.
also perhaps saying the same thing. Let us
What I'm trying to
PW
portray
could be
for your
different.
lordship
one
is
minute. Let
that
us understand the.
Yes.
I will hear it
my,
after lunch. I am just understanding. And then I'll tell you the task to how to do it. Yeah?
I will just slowly read once again. That day, as the tube well of our locality was out of order, myself, along with PW1,
Where are you
Bandita
reading?
Suna,
Where are you reading?
the PW2 statement, your lordship.
I read it. The PW3, come to PW3.
This paragraph 2 was very important. What we're trying to say is
I will go through.
My
I'm
lord.
just getting a overall
My lord.
idea. Overall idea.
PW3 is the medical officer.
PW3 is medical officer.
Yes, your lordship.
Simple injury. He found simple injury.
Simple injury, but during the cross examination, he admitted that by means of a thin stick would not cause the swelling injury. Cross-examination, Your Lordship. 3, paragraph 3. It is a fact
It
that
is not a fact that such swelling.
it is a fact that assault by means of a thin stick would not cause the swelling injury of the nature found as per Exhibit 1. That's the medical report.
That is a suggestion that whether that the injury can be caused by a thin stick or not.
Who is 4?
4 is, my lordship, another complainant.
Okay.
One of the victims.
But in the Suna.
Abusers and so.
The accused persons came there and abused us.
Accused Vikram Ashal.
But in this, they have changed the statement a little bit. She has gone far beyond that. That we have.
See, madam, now you concentrate on one thing.
1, 2, and 4.
One thing, that all the 3 informant victim and all of them have said that these people came, prevented them from taking water, saying
Water
that
from
you
this.
belong to that caste and all. That is a specific offense for that in
Yes.
SC state. Preventing to use common
Water bottle.
water pools and all
Yes.
is a specific offense. That
They
is
have-
not believed by the trial.
That have been acquitted.
They have been
They have been
acquitted.
acquitted. Yes.
That part of the story is completely not believed.
Not believed.
And
yes.
what is believed now is Bikram is assaulted.
Not
Bikram is the only guy who is assaulted.
No, BW.
No, I'm just giving a
Yes.
Bikram is assaulted. If that is the case,
Yes, sir.
and which stood corroborated with the PW 3, the doctor, simple injury.
Simple.
323 conviction is there.
It is there. Yes, sir.
Why the other accused person shall not
Yes,
be
sir.
acquitted and only Bikram will be convicted for 323 and PO will be granted?
Yes, sir. I'll
Just concentrate there.
Yes,
At
sir.
2 o'clock.
I'll just reread the PW 1, 2, and 4. I'll concentrate with the only 2, 3.
149, how will you bring?
No, Your Lordship,
How will you bring if the court doesn't believe the story
Yes, sir.
and record an acquittal insofar as
That is only I'll place evidence of PW 1, 2, and 4. Nothing more, Your Lordship. 1,
to
2, and
bring
4.
149?
149. 149.
You concentrate in 149.
149. Yes.
Why 149
Against the.
against all the remaining accused persons will
Yes.
be raised in the face of an acquittal
Yes, sir.
under a specific charge and a specific statute?
But-
That's the
Yes.
case.
I'll
If
answer.
you can satisfy, then 149. Otherwise, Bikram is assaulted,
Yes, sir.
that stood corroborated
Read-
with
I will also
doctor's
again
evidence.
show this
323.
There's a rivalry.
I'll just
It's a
read
backstory.
1,
Those
2, and
again,
4.
another. Let us 140. You concentrate on 149.
My lords.
Yes.
If 149 you can successfully convince,
Then automatically others go.
then the others go. And Bikram is there. Okay, 323 Bikram
Yes.
will do, and PO will do.
PO will
That's
do.
that's the whole idea. Okay.
I'm grateful.
Item number 7.
Hmm.
No, can I pray for Tuesday?
Tuesday.
Can I pray for Tuesday?
Tuesday.
Your Lordship, I'm serving my note of citation along to them.
Tuesday. Tuesday is the first item. Huh?
First
I'll
item.
take it the first item.
First item.
Please, that's the log. Item 12.
Your lordship, and it's a deposition of PW5 with the officer in charge.
Continue, print out card.
I will lead your lordship to the cross examination. Sorry.
Print out card. Print out card दिया. Under yes.
I will lead your lordship to the cross examination of PW5.
5. Yes.
Paragraph 8.
Right. Yes. During the investigation.
Yes. It has never been brought to my notice that any of the accused persons belong to scheduled caste or scheduled tribe. It is not a fact that I have not investigated the case. Now, paragraph 9, your lordship. In course of spot visit and preparation of spot map, I have verified regarding the locations adjacent to the spot. Spot is surrounded on the east by clubhouse, on the north by the cow shed, on the southwest the Harijan Pada, and on the west Buddhipadar some road. There is a rice mill near the spot situated at a little distance on the visit but not adjacent to the spot. It is a fact that there are houses also at a little distance on the spot. So what I brought to notice, Your Lordship, is that even when there is an occurrence, somebody has been hit by a stick or whatsoever means, it's a village. If something happens, everybody knows. Now, these 5 accused persons, they have hit a lady, 3 ladies together, and nobody knows about it. There's an independent witness to the incident. It mentioned that the accused persons pushed PW4 and others. It has been mentioned in the FIR that both the accused persons came and raised protests against taking water. Now, the FIR has been filed against 5 accused persons, but the written FIR given by the victims says that there were 2 persons. Now, I will lead your lordship to the medical report
Yes.
of PW1.
That is doctor.
Yes, your lordship.
PW.
The medical examination report.
He is the doctor.
Hmm?
He is
PW
the doctor.
3 is the doctor.
Yes. Read 3.
The report says
Hmm.
that the age of the injury could not be ascertained,
Hmm.
as there is no bruise or abrasion.
Yes.
Kindly see PW3 for a minute.
Yes.
See, in paragraph.
Banita is PW.
Banita is, my lord's, PW1. I'm sorry, PW3.
PW.
The Banita is PW4.
PW4. Only Banita is examined by the doctor.
Both Banita and PW1. PW4 and 1. One says that she has a
One
minor
minute,
bruise.
Where is that?
The just below that medical examination report of Banita Suna.
Read PW3 full.
Yes, yes.
As working in the present force and so and so. On that day, so and so police requisition examined of Banita.
After Banita,
And found when swelling in so and so.
The injury was
One
simple in
swelling
nature and probably
found
caused
it
due to hard
one
blunt.
swelling and diameter of so and so so and so.
I could
The
not
injury was
ascertain
simple
the
in
reason.
nature and probably caused by the hard and blunt weapon. I
The
could
next
not
page, Your Lordship.
ascertain so and so so and so.
Ascertain the
On the
age.
same day, I examined 15
Kshatriya.
Kshatriya. What PW?
1.
PW1.
Banita is, my
PW.
lord's, PW3. Sorry, 4. PW4. Banita
1
is
minute,
PW4.
don't get confused.
Examines 1.
So and so, what is the injury?
Found it
What is the
following.
injury? Following injury.
There are 2 bruises.
What I'm harping upon is that the age of
Both
the
injuries
injury.
are simple in nature, probably caused in hard and blunt
Age of the
weapon.
injuries was
So
within the
and so.
24 hours before my examination.
Which portion of which where? On the knee. Ah. Right knee
Right.
and left elbow.
Yes, Your Lordship.
Left elbow, right knee,
Yes.
and swelling where PW1 swelling nature so and so. Right elbow. See the injuries of PW1. What he says? He says PW1.
PW1's injury says that she has a bruise on his left elbow
1 minute.
and a bruise in his right knee, which is within the.
In para 3, she states all of them physically pushed us, whereas accused Bikram assaulted me and my companions with a bamboo stick. I sustained injuries. Banita Suna also
Assaulted
sustained
me?
injuries due
Bikram, huh?
Huh.
Bikram assaulted me.
Bikram-
He doesn't say where, which part. Sustained injury.
Yes.
Banita also sustained injury due to assault by Bikram. Okay? And let us see
He says
PW.
all of them pushed. The Bikram, specifically Bikram, assault.
Where they have, which part of the body they have not, haven't said.
Not,
Para
not
7.
mentioned.
Para 7, she has said. I
Para
sustained-
7.
Para 7.
Yes.
I sustained injuries on my right thumb,
Just an injury on my right
right thumb,
thumb.
right toe, and left elbow. Those were bleeding injuries.
This contrary to the report.
Then corroboration is there.
Yes.
PW4 injuries are
She says,
Accused Vikram-
assaulted by means of a bamboo stick on me. I sustained a swelling injury on my right elbow.
right elbow
Due to push, PW1 fall down on
and knee. Right
elbow,
elbow.
knee and toe.
Yes, Your Lordship.
Yes.
Now, Magistrate considers the deposition of PW2 once again.
Uh,
PW2 says on that unfortunate day, she, along with
uh, yes.
PW1, Banita Suna, Gharjugi, I read paragraph 2, Your Lordship.
Yes, I'm reading that.
Gharjugi and Kunjalata. That means a total of 5 women were there on the place of incident who were taking water from the tube well. Total 5 ladies are there, Your Lordship, if I'm very, very clear on that. PW1, Banita Suna, Gharjugi, and Kunjalata.
Yes, yes, madam. 149.
Pardon me.
149. How will you
Sir,
get?
I'll just place PW1 and 2.
I read it full. You tell me.
I'll just indicate the particular line. PW1.
Yes. Which part? The overtake is all of them came and said that you can't take water from that
Yes.
well. That part of the story is disbelieved by the trial court. Therefore, acquitted all of them for 3-1x.
3-1.
So that part goes.
Yes, sir.
Then if that part goes, the participation of other accused persons in the entire incident is also doubtful. Therefore, 149 straight away goes. If 149 straight away goes, then the only thing which remains is Bikram assaulted,
Bikram assault.
which stood corroborated with the doctor's evidence.
Yes.
So 323, simple injury, T23, 323 Bikram. That's all.
There are 5 accused persons, and admittedly lackey was used.
What is the overtake attributed to these 5 people?
So, paragraph 3 of the PW1.
PW1, paragraph 3.
3.
Yes, read it. Read it.
Yes, sir. 3 lines from the top. I'll read the exact.
When we were-
All of them physically pushed us, whereas accused Bikram assaulted me and my companions with a bamboo stick. So all of them here. Thereafter, all of us went to the.
But that part, the previous part, that these people were participated and prevented these women from taking water from the. That part is not believed by the trial court.
So there are 3 different offenses were involved. One of them, like relation my endeavor would get, there are 5 accused persons. To satisfy the ingredients of 149, 5 would be due. And they're armed with lat. And PW1 in a statement in paragraph 3 stated, all of them, all 5 accused persons pushed her and her companion. Thereafter, the accused Bikram specifically assaulted the PW1 and 3. So the participation needs credence to the 149 Your Worship. Thereafter, PW2 also. PW2 paragraph 2 years.
Come to cross examination of the same witness which you are reading, para 5.
It is not.
I had not stated before the IO regarding the involvement of the accused persons, Dayanand and Damaya, in the alleged occurrence, that I have not
Name them before.
named them
Yes, sir.
before the IO.
The sentence started, it is not.
It was accused Bikram who abused and threatened. It is only Bikram.
I'll just reread that statement. It is not a fact that I had not stated before the IO regarding the involvement of accused persons, Dayananda and Dayamoy, in the alleged occurrence, and that I have not named them before the IO, and it was accused Bikram who abused and threatened us.
Come to IO. Come to IO. What IO says? What IO says regarding this?
Para 12. PW1 Simati Benla Kshatriya has not stated before me that any other than PW1, 2, and 4 Banita went to fetch water. And regarding the involvement of accused persons, Dayananda and Dayamaya, in the alleged offense, PW1 has not named accused person Dayananda and Dayamaya. She has not stated that it was accused Bikram who was abused and threatened them, and the accused Bikram assaulted her by means of bamboo stick, and the accused Bikram assaulted and caused injury on Vanita Sultan.
The next paragraph also, 13 and 14.
That is regarding PW21.
And 14 is very crucial as far as I'm concerned.
To para 12, it is not necessary. He says that these people are not have not participated. That PW 14, para 14.
Very important.
12 to 14.
Hmm.
Regarding 1 to 1.
Yes, it creates a serious doubt now.
14 is very, very important.
Let's see, this pushing thing has not been stated before police. It was in the FIR also. Yes.
सर लेकिन उभय आसी डाकिबारु आम्बको भीषण माड देई खंडिया खबरा कर देइछन्ति एवं नाना को नखा प्रयोग करी इज्जत नेइछन्ति
FIR,
Minus.
the TCR.
Yes.
18? 1 minute.
18/12/95,
There are?
page 4 here, sir. Page 4 of the TCR.
Judgment लगा दिया पीछे. अच्छा, arrested on
18/12/95,
18/12/95
95. By order date 3/1/96, they have been released on bail.
3/1/96
96.
bail, huh?
Page 4 of the TCR.
Let us see. Sit on.
16 days.
Around 16/17.
All the cues.
All the accused.
No, just see final form.
Fine.
Final form, if you see 18/12, okay. 18/12.
The accused arrested on 17/12/95. They must have forwarded on
18.
18/12/95. Order shift to the magistrate at page 4. By order the 3/1/96, they all have been released on bail.
3/1/96, huh?
3/1, page 4 of the ETC.
Yes. Allow the principal to release. So then how many days this is?
Around 17 days.
3 days here and
16.
16 days.
अपना बेल बॉन्ड जो दिन देते हैं.
Just see bail bond. Bail bond.
3/8/96 or whatever. Let us.
On the same day they have given the bail bond.
Same day?
Same day they have given the bail bond and release on bail.
They release on that day.
3/1/96.
So 16 days are undergone.
16 days.
16 days. What is the sentence?
6 months.
6 months. And fine also?
There is no fine.
All 5-6 months. 6 months.
Fine also.
No fine.
Fine is also there.
No fine.
No fine.
No fine.
Fine has.
चलो पीओ करके छोड़ देंगे और क्या. The incident is 99.
95.
95.
16 days already undergone. देखो जी. चलो.
Only victim can be sustained.
And this.
All these people, village politics and all you see that.
I'm just submitting.
Huh?
I'm just submitting also.
95 some incident happened and okay.
I'm grateful.
Thank you. Thank you.
I'm grateful for the opportunity, Your Lordship. Thank you.
49. 49. 49.
He has already passed the judgment. He has already passed the judgment.
What is the judgment? You tell me so that I will not labor.
ସାଙ୍ଗଟେ ଅଛି ଜେଲ ମାନେ ଯାଇଛି ପିରିୟଡ଼ ବର୍ଗଙ୍କ ଛାଡ଼ିଲେ 6 ମାସ ପାଇଛି 323 ଆକ୍ଟୁଆଲି କେମିତି ହବ ମୁଁ ବୁଝିପାରୁନି ଆପଣ କଣ
Are you aiming at acquittal? Then I am hearing.
Otherwise ହବନି ସାର୍
Undergone.
ଆକ୍ଟୁଆଲି ଜମା ହବନି
49. Like ଦେଖିବା.
ଜମା ଚାନ୍ସ ନାହିଁ.
Just let us see what is. What are the offenses, by the way?
506-307
Convicted under which provision?
Convicted only under 323/34.
Show me the victim and doctor.
My lord,
Period 3 years.
your lordship may kindly turn to
ନା ନା period 3 ଟା ଆଉ period 5
Doctor,
PW3 is the injured.
let us see.
No, your lordship may kindly, my submission before the lordship is that he has acquitted me from all charges. but convicted me only on
323. Yes, yes,
So that portion may kindly be seen in the judgment.
yes.
See,
Yes.
injuries are simple in nature. Weapon
Which
of
paragraph? Which paragraph?
para, para
Your
India.
Pedo 5 is the medical officer. Doctor.
Let us say, no, she is showing the judgment. Part of it. Let us.
Judgment, your lordship, may kindly turn to page 11, internal page 11, para 11.
Yes. The prosecution heavily relied.
Yes.
The evidence appeal 1 to 4.
1 to 4 prove assault to
Schedule 3.
by the accused persons. Then next para, PW 2 and 3 have clearly stated about the assault to the PW3 by the accused persons. According to PW3, the accused Mukunda Sahu dealt a blow on his head by whom split, whereas the accused Prasanto Sahu dealt a blow on his chest and his left leg on wooden planks. And also, thereafter, a lordship may skip page 12, skip 5 to 10 lines that but then PW2 is a rustic villager and in his earlier cross-examination on so and so, he has clearly stated that the accused persons were holding wooden split. Thus, it can be said that he has heard in speak on 16/12/2009 that the accused Mukunda Sahu dealt a bamboo. Hello, question is
It's minor discrimination.
yes, yes, yes. But my submission is he is relied on PW2 and 3. So far as 223 is concerned, Lordship may kindly turn to the evidence of PW2 and that way
3. Let us see first 3.
Right. 3 is the injured.
Injured. Let us see.
Yes. 3 is the injured.
Prasanto Sahu and Mukunda Sahu. Yes. I'm the informant in this case. I know the questions. I go for a duplicate.
I am the information.
Were hiding in the cow shed of so and seeing me, they came out, powder and everything, so. And if Mukunda Sahu dealt a blow in wooden on my head, causing me deep injury. Santo Sahu dealt a blow on the wooden sheet on my chest and left leg. Head, chest and left leg.
Yes.
Okay?
Yes. All are simple in nature. That is one part.
Doctor,
Then
doctor is doctor.
PW5.
PW5.
Let us see where are the injuries.
4
Head.
individuals.
PW5. Yes. 3 injuries. 4 points.
Head injury is there.
In that.
Ankle injury is there. Chest injury is there. And
One
now
part.
the injuries are corresponding. Whatever they have said, that's corresponding.
Are simple in nature.
They all simple in nature.
Yes.
323 therefore.
My lord, so far as PW2,
Two,
has
let us see.
relied on PW2.
2 and 3
2 and
corroborates
3.
with 5. That's what case.
Yes. 2.
Let us see the 2.
2. Yes. Cross-examination, your lordship may kindly see. I cannot say the date, month, so and so, your lordship may see it. It is a fact that there is a road leading to village so and so, but at the time of Alice's occurrence, I was proceeding in the road leading to pond. There is a road up to village pond. There is no road after pond. My field situated at distance of so and so. I had been to my field to inspect availability of water. It was about 4 p.m. When I reached my field, I stayed there for 1 hour. Nobody was there when I was returning to my house. No outsiders were present at the spot when the occurrence took place. I saw the occurrence from a little distance. Your lordship, I am pressing this part. When I reached near the spot, I found the accused persons running away from the spot. So he has not seen.
Accused Prasanto Sahu abused saying so and other accused also abused the filthy language. And both the accused persons were holding wooden, but I cannot say the size of such occurrence, and I had no enmity with this person, but is not a fact that no such occurrence. He might not have seen, but the fact that she sustained some injury stood corroborated with the five.
But it should be corroborated material particulars.
Five.
Five, my lord,
Five.
so far as the injuries are concerned, my lord, if those injuries are there, my lord, I have been acquitted from all.
Therefore,
All other-
323.
Yes, my lord, that is true. I don't say
Only
no.
323.
Yes. And paragraph 3, further cross-examination of
Undergone 1 month.
1 month.
Already undergone.
ସେଇ କଥା ମୁଁ କହୁଛି
Already undergone.
ମୁଁ ତ କହିଲି ସେଟା ଜଜମେଣ୍ଟ ଆଗରୁ ପାସ୍ କରିଦେଇଛି।
ପୁରା ସବୁ ଜିନିଷ ଅଛି ସେ ଦେଇନାହାନ୍ତି
ହଁ, ସବୁ ଜିନିଷ ଅଛି ତ। Yes.
Already undergone. काम कर रहा हूँ।
2 days.
चलो, already। कितना है?
ଲାଷ୍ଟ ବାଲି ଲାଷ୍ଟ ପଳେଇ ଆସିଛନ୍ତି
इधर से कितना है?
ଏ 5-6ଟା ହେଇଯିବ ସାର୍ ସେ ଯୋଉ ଲାଷ୍ଟ କୁ ଅଛି 323 ଏମିତି ହେଇଯିବ 50 51 52 ଦେଖିଦିଅନ୍ତୁ ସାର୍ ସେଗୁଡା
43 51 छोड़ो 43
ଏ 323 ବାଲା ଅଛି ଲାଷ୍ଟ ସେଗୁଡା କାଢନ୍ତୁ ଆପଣଙ୍କ ପାଖରେ ଅଛି
43
ତୋର 43 ରୁ ତୋର
43 ରୁ କାଇଁ କରୁଛନ୍ତି?
323 वाला तो साइंस में कहीं तो नहीं
ସେଇଟା
ଆପଣ କୋଉ
adjournment item number 15.
it will remain, don't worry, you come whenever you will come, I'll hear you, don't
He
worry.
is asking for the hard copy of the because
ठीक
in this matter actual soft copy से देखा जाऊँगी not visible.
सॉफ्ट कॉपी दिखाओ सेटू काम पड़ुछ हार्ड कॉपी जस्ट सी फाइल must be worse than that, must be worse than that, at least you can read it by enhancing it, but hard copy is very pathetic, very pathetic.
सब पेन ड्राइव पे दियो
पेन ड्राइव नियंतु थाउ तो एटलीस्ट थाउ हां 43 की अछि मानस्टन कोन आला 43
6 month 1000
6 month 1000 323 only 323 हां
से तांकर एसोसिएट थिला ना जोटा कोन के
सकाळ
हां ओकरा के सना बोली कहिथि
हां
थिला से
एसोसिएट वस्तु देनी कहली
कहला टिके आस्तु बोली कहि
डिस्प्ले कॉपी
এটা था এই যে টিউসডে से था ना से
imprisonment for 2 months 323
2 months.
only 2 months
Only 2 months. ये रिटर्न करके छाड़ दे हे ये पहले देखे चला
देखो ना भैया देखो करो ऑलरेडी just see, otherwise see I'll tell you these matters will never be finished, never ever will finish. Incident pertains to which year? 2000. How many देखो ना
26
you were 31 years in the year 2000.
26
40 के 43 थे ना ये तो दिखा Twenty-six 5/2001 arrest.
One arrest, yes, sir. ଗୋଟେ 15 to 2006 ଗୋଟେ ସେ ଲେଖିଛି ଯେ release on bail ବୋଲି, କିନ୍ତୁ ଇଏ 5 ବର୍ଷ ତ ନଥିବ ନା, 307 ରେ ରହିନଥିବ।
Just check it up.
Thereafter, October 2006, released on bail or furnishing the.
Do one thing, do one. Yeah, aram it can be disposed of already undergone. At item, just check it up, note it down, and I'll list it on the top of the list. Okay? Indication they do. So and so matter will be taken up first. Wherever you get the undergone period, you tell me so that we can take it up in the morning and finish it up. 8 matters. Okay? And working base. Okay? I'll just record.